please.
Did you say our Christmas dinner?
It's like everybody else, a delegate.
Well, I remember discussing it, but I don't remember an example. Choose the dates other than the 19th. No, I was listening. I was probably in follow. And the phone water range. No, I just remember it definitely. I just.
I started about. I kind of like that little text.
Okay, let's do the transported individuals. We ready over there? You ready? Mr. Fox, you ready? Commonwealth versus James Adams.
Hopefully we will.
Commonwealth versus James Adams, 21 CR 00124. Are you James Adams?
Yes, sir.
Good morning. Were you born in 1980?
Yes,
Last four digits, social security number 0918.
yes.
We're here on a probation revocation. What does the Commonwealth have to say? If y'all step to your left a little bit.
No, this was a 5-year sentence on wanton endangerment first degree. Mr. Adams had a positive meth test back in June. Then he had positive marijuana test. He was charged in district court. That case was dismissed. He was referred to drug court and he was voted in this morning. So if the court will approve it, he can be oriented and start drug court.
Okay, well, we'll let you out as soon as you get oriented and start in the drug court. Does that sound like a good deal?
Could I be released today, please?
I cannot release you until you get oriented.
Should be within the next couple of days.
Just a couple of days. Yeah. Good luck to you in that. You still got a right to turn yourself around
I think Mr. Gray said Monday.
Monday, okay?
I have to sign drug court waiver for the
I
file.
can't hear you.
I have to sign drug court waiver for the file.
Thank you. Yes. I don't know about those. Dalton Birdwell. And they have a list over there. They have a docket list over there so they can have the next one ready. Could you check and see if they do?
Thank you. Here's Ray.
Hey, I have a question.
Commonwealth versus Dalton Birdwell, 22 CR 0051 and 24 CR 0058. Are you Dalton Birdwell?
Yes, sir.
Good morning.
Good morning.
Were you born in 1998?
Yep,
Last four digits, social security number 5368.
yep.
We're here on a pretrial conference. What does the Commonwealth have to say in these cases?
We have a felony plea, yeah.
And Your Honor, with regard to the other case, we're entering a revocation order.
Well, I didn't have a revocation on it.
I have a,
Which one of them is it? I don't need it right now.
22 CR 51.
So that was an error on here. It's a revocation. You're stipulating to that, correct?
Your Honor, as
Okay.
part of the global resolution.
So I will do 24 CR 0058 here. A motion's been tendered, Mr. Birdwell. It says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? Are you the same person we just identified in 24 CR 0058 and 22 CR 0051?
Yep.
Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Yep.
Have you had plenty of time to review the evidence in this case and you feel like you're fully informed?
Yep.
You know, you don't have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have, and I'm gonna go over them and then ask you, okay? You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at all stages of proceeding and at trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, have process issued to compel their attendance. You have a right to appeal this matter to a higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering this guilty plea today, you give up those rights. You understand that?
Yep.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept it. Prior to accepting the recommendation, I'll await the pre-sentence investigation report to be done by probation and Monroe. In the event that I decide to give you a more harsh sentence, you have the right to withdraw your plea. Do you understand that? Can we step to the left, please? Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to burglary third degree, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to theft by unlawful taking or disposition over $10,000, the defendant shall receive a sentence of 10 years. Upon a plea of guilty to facilitation to criminal syndicate engaging in organized crime, the defendant shall receive a sentence of 5 years. The 2 5-year sentences shall run concurrently for a total of 5 years, and this 5-year sentence and the 10-year sentence shall run consecutively for a total of 15 years to serve. The 15-year sentences shall run concurrently to indictment number 22 CR 51. The Commonwealth opposes probation and shock probation. The defendant agrees to have any and all evidence in the above style case forfeited and destroyed in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to, Ms. Burwell?
Yes, sir.
Okay, you're pleading guilty because you did commit the acts charged in the indictment as amended.
Yep.
You're doing so your own free will. Knowing your constitutional rights, I previously explained to still your desire to waive those rights and allow the court to set your sentence within the range permitted by law. Is that your signature on the document?
Yes, sir.
I'll accept the agreement, order pre-sentence investigation report to be done by probation, parole, and schedule your sentencing for December the 12th. Okay?
And
Claude Caven,
then Judge, do you want the revocation order as well?
yes.
I apologize. I did not have.
Stipulate that, I'll enter that order.
Yes. Don't.
They will have a revocation. No. Yeah.
Commonwealth versus Claude Caven, 24 CR 0082. Are you Claude Caven?
Yes, sir, Kevin.
Caven, excuse me. Good morning.
Good morning.
Were you born in 1998?
Yes, sir.
Last 4 digits, social security number 0475.
Yes, sir.
You're here today on pretrial conference. What do we have?
Felony plea, Your Honor.
Felony plea. Motion's been tendered, Mr. Caven. Is that correct, Caven?
Yes.
Okay, a motion has been tendered, says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
Yes.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 24 CR 0082?
Yes, sir.
Is your judgment impaired today in any way?
Yes, sir.
Okay, have you discussed this matter with your attorney and are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Do you believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to plead guilty today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a guilty plea, I need to know that you understand those rights. I'm going to go over them and I'm going to ask the end if you understand them, okay? You have a right not to testify against yourself. No one can make you say anything. Your right to speedy trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, your right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting any recommendation, I will await the pre-sentence investigation report done by probation and parole. Is this gentleman a state prisoner now?
No, Your Honor.
In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, then you have a right to withdraw your plea and go to trial. Do you understand that?
Yes, sir.
Ms. Gordon Anderson, what's the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to bribery to a public servant, 2 counts, the defendant shall receive a sentence of 7 years on each count to run concurrently for a total of 7 years, probated for 5 years, supervised. The defendant shall enter and complete the Monroe Specialty Drug Court Program. The defendant is currently incarcerated and shall remain incarcerated until the morning of orientation for drug court. The defendant agrees to have any and all evidence in the above style case forfeited or destroyed in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that your understanding of your recommendation, sir?
Yes, sir.
Are you pleading guilty because you did commit the acts in the indictment as amended?
Yes, sir.
Do you plead guilty of your own free will?
Yes.
The knowing constitutional rights I previously explained to you, is your desire to go ahead and allow the court to fix your punishment in the range of sentence provided by law. Is that your signature on the document?
Yes, sir.
I'll accept the pre-sentence investigation report done by probation and parole, schedule of sentencing for December the 12th.
So if you're looking for
Seth Graves.
I didn't transport it. I didn't have a transport, but he's at the jail.
Okay, we'll make sure we see Seth Graves when we do the Zoom, okay? Herschel Hammer. Herschel Hammer, Commonwealth versus Herschel Hammer, 23 CR 0083 and 24 CR 025. Are you Herschel Hammer?
Yeah.
You good morning.
Yes, sir.
Are you born in 2005?
Yes, sir.
Last 4 digits, social security number 5631.
Yes, sir.
We have a probation revocation here. What do you have to say, Mr. Stockton?
Mr. Hammer had a 15-year sentence and he was out of pocket or absconded for about a month, and Mr. Collins finally let him turn himself in, and there may be a new criminal case based on his actions, not being
You
supervised.
want to stipulate?
Judge, in light of that, the Commonwealth and the defense had discussed passing this to until December to explore whether or not there will be the new case. And if there
I
is,
don't want to pass it. You either stipulate or we'll have a hearing.
Judge, we'll have a hearing.
Okay, call the witness. Just step to the left here a little bit. You raise your right hand. Swear the testimony you're about to give is the truth, whole truth, nothing but the truth.
I do, Your Honor.
Go ahead.
State your name, please.
Chase Collins, and I work with Probation and Parole Department of Corrections.
Have you been supervising Mr. Hammer?
I have. Supervision began with Mr. Hammer on 8/15 of 24.
Okay. August 15,
Yes,
and has he had any violations since then?
he has.
And what
Mr. Hammer absconded. On 9/12 of 24, Mr. Hammer reported for his regular rescheduled report date and was given a next report date of 10/9 of 24. On 10/9, he failed to report as directed. On 10/15, Sheriff Frog Ford, Monroe County, called me, stated he had found Chris Burks, but he had ran from him. He stated he was standing there with Mr. Hammer, and I stated he was also on probation. He stated Herschel was with Chris Burks and some stolen items had been recovered. He put Landon on the phone. I told him he missed his report day. You're sure?
No,
Oh, I thought you said something. I'm sorry. I told him he had missed his report day the week prior on 10/9. He stated he would report to me on 10/15, the same day, to the Glasgow office, and I told him to be there before the close of business. On 10/15, Mr. Hammer failed to report as directed again. On 10/16, I called him again, or he called me, and stated he had arrived after hours on 10/15. I told him he needed to report on the 16th, on this day, and he stated he was on his way. He also failed to report on that day. On 10/22, I tried calling with no return calls. I spoke to the subject's father on the 22nd. He stated he didn't really know where he was. He would try to find him and try to get him to me on Monday, 10/28. I also spoke with his sister, and she stated she would have Landon in my office on 10/23 before lunch. 10/23, I spoke with his sister Destiny again. She stated she had talked to him and he needed to report via Facebook Messenger. She stated that she did not know where he was staying at the time, did not know where he was at. 10/23/24, I also spoke with a Brandon Coulter, and Mr. Hammer was residing with. He stated he left his home on 9/14, 2 days after he brought him in to report to me on 9/12, and did not know where he was at. And we issued a warrant for absconding after that. I couldn't find Mr. Hammer.
So ultimately, was he arrested or he just turned himself in?
He turned himself in to Deputy Richardson.
Okay, you remember when that was?
I can't remember the exact day he turned himself in.
I'll ask him.
No, I don't have
So-
any questions.
Would you like to inquire, witness?
Judge, I have a couple of
Yeah,
questions.
go ahead, please
Yeah.
proceed. Yeah.
Officer. When, Mr. Hammer missed the report date on October the 15th, did you attempt to call him?
Sure, numerous times.
Okay. And did you attempt a home visit at, the address listed, which is in Camellia?
Mr. Coulter stated to me that he was not residing there, so it does not require a home visit.
Okay. And when did you have that conversation with Mr. Coulter?
On 10/23.
Okay, but you didn't do a home visit prior to that, or didn't attempt a home visit prior to that?
No, I had not done a home visit. No, not yet.
And that's all the questions I have.
No reason.
Any other witnesses? Would you like to call any witnesses?
No, Your Honor.
Okay. Make your argument come around.
Your Honor, I bet it gets a long time. I think.
If you get behind the microphone, I can hear you there.
Thank you. A gentleman that's deceased now that I used to go to church with, and he always told me, he said, if you show up to work early, you don't have to work so hard. If you show up to probation and just meet with them, they'll work with you, and more than likely you won't be revoked. But this is a common problem we have in all three counties. Most of the probation officers spend their time trying to chase people down instead of being able to supervise them. So I don't think there's any choice but to revoke Mr. Hammer.
And Your Honor, I'd ask the court to not revoke
Get
Mr.
behind the
Hammer.
microphone, please. Would you get behind the microphone?
I would ask the court to not revoke Mr. Hammer, and take into consideration that Mr. Hammer did turn himself into law enforcement, that, the, appointment that he missed with probation was on October the 9th, and that he, turned himself in to, Monroe County Sheriff sometime between October the 23rd and when he, came into custody at the Barron County Jail. And I would ask the court to instead, issue a graduated sanction. I think that Mr. Hammer did prove that he could be supervised in the community, and that he's not a danger to the community. And I think that, we would ask the court to not revoke and instead issue a graduated sanction of a jail sanction, or whatever the court deems appropriate to ensure that Mr. Hammer is compliant with probation.
I think Mr. Hammer is an absconder. He had numerous orders to report. Evidently made misrepresentations to his family and other people. You just don't get to come and go the way you want to when you're on probation or parole. You're supposed to comply. And this is not a joke, okay? Now, I didn't hear any evidence of any other crimes that he might have committed, but at that juncture, I'll take into consideration the fact that you did turn yourself in this first case. When we consider that, we'll see what the Commonwealth negotiates. But I'm at the end of my patience with people that do not comply with the privilege that they get of being free. The only thing you gotta do is cooperate. You know, and report when you're stated to, and on numerous occasions you didn't do that. So unfortunately, I'm going to have to revoke your probation, and then we'll see what happens with the grand jury on the other case, okay?
Thank you.
Concepcion Lopez,
Have a order on him. So he did today.
he will, Mr. Lopez will be zoomed. Thomas Ludwig. Commonwealth versus Thomas Ludwig. 20 CR 0083. Are you Thomas Ludwig?
Yes, sir.
Good morning. Were you born in 1971?
Yes, sir.
Last four digits of social security number 2886.
Yes, sir.
We're here on 20 CR 0083 on a probation revocation. What does the Commonwealth have to say?
Your Honor, this is a
If you'll
case.
come
where-
around to the microphone, it'll be good.
This is the case where the court heard proof a few months ago, actually 3 months ago.
And where he had a misdemeanor conviction in Tennessee for failing to register as a sex offender. And you were waiting to see if he could get a job and housing.
And Judge, with regard to that, my office has been working with Mr. Ludwig to see what it is that we could provide for him. Unfortunately, the resources that the Public Defender's Office has with regard to housing and employment in an area such as Monroe County is very limited. The issue is not a job. He would be able to go to work if he had somewhere that he could be released to live and then go to work.
I understand what the problem is. That's the reason we gave him time to find some placement.
Yes, Your Honor.
What are you
Well,
suggesting now?
What I would ask the court is to consider releasing Mr. Ludwig to give him the opportunity
I'm
to
not going to
arrange.
release him until I find out where he's going to be.
Judge, we are not able to help him.
Okay, well
We
then,
have tried for months and we're not
I'm not
able to
able
do
to
so.
help him either because he is a registered sex offender. And he failed to register at the last place he went. And I'm not going to release him on the public without a location where he's going to be. I just can't do that.
Judge, what the release we would be asking is not a straight out release. It would be that he would be monitored in some way, which could include
I'm
reporting
not
to
going to do
probation.
it. I cannot do it. If you give me any kind of location that it'll be, even if it's for a temporary period of time, I'll let the man have a chance to go to work and that sort of thing. But I just can't put him out on the street and he can't register if he has no place to register. How can he register?
Judge, we don't have resources for that.
I don't either. Okay? Okay. So, I'll deny your motion then. Thank you. Joseph Martis. Joseph Martis. Commonwealth versus Joseph Martis, 24 CR 0051. Are you Joseph Martis? Joseph Martis,
Yes, sir.
good morning. Were you born in 1985?
Yes, sir.
Last four digits of social security number 9135.
Yes, sir.
We're here today on a pretrial conference. What do we have?
The felony plea, Your Honor.
A motion's been tendered that says you wish to enter a felony plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 24 CR 0051? Is your judgment impaired today in any way?
I'm sorry.
Is your judgment impaired in any way today? Have you discussed this matter with your attorney and are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you?
Yes, sir.
You believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under Kentucky and the United States Constitution. And I need to inform you of those rights and ask you to understand before I can accept a plea. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor. The right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendations. Prior to accepting the recommendations, I will await the pre-sentence investigation report from probation and parole. After reviewing that report, if I decide to give you a more harsh punishment than the recommendation the Commonwealth gave you, you'll have a right to withdraw your plea and go to trial. Okay? Now, you step to the left there a little bit. Yes. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to assault fourth degree domestic violence, the defendant shall receive a sentence of 5 years, probated for 5 years, supervised. The defendant shall enter and complete anger management classes and enter and complete long-term treatment facility determined by and scheduled through DPA and agreed upon through an agreed order by the Commonwealth. The defendant shall remain incarcerated until the morning of his bed date. The defendant shall have no contact with the victim until approved by the court. The defendant shall pay $1,000 fine and costs. The defendant agrees to have any and all evidence in the above style case forfeited and destroyed in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that the recommendation that you agreed with, sir?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
You doing so of your own free will?
Yes, sir.
Knowing your constitutional rights that I've explained to you, it's still your desire to give up those rights in your plea of guilty and allow the court to fix your punishment in the range permitted by law. Do you understand that after any guilty plea, any future convictions could be enhanced as far as the range of penalty under persistent felony offender law? Do you understand that? Is that your signature on the document?
Yes, sir.
I'll accept the agreement or the pre-sentence investigation report be done by probation parole and bring you back here on December 12th for sentencing.
Thank you, Your Honor.
And by then you'll need to get, counsel, you'll need to have the arrangements where he's going to be released to.
I already have that. I have provided a bed letter to the Commonwealth this morning. We'll be tendering an agreed order. The bed date is November the 19th. Yes.
Thank you.
Thank you.
Wait, is
The
he,
only problem is we want to make sure he's available.
he's got to be sentenced.
Yes, so I confirmed with the treatment program that they will bring him in person on December the 12th to final sentencing.
Well, he's not under bond or anything. I don't understand that. I just don't think he can go to his sentence.
You're the, whatever. the
Well, I mean,
desires.
you see what I'm saying? What's the bond set for? Do you have a bond?
Judge, he's been unable to make his bond because it's a financial cash.
And where's the location that
It would be in Russell Springs.
I mean, we've got an assault here. Okay,
And this is not the first one, it's the third or subsequent.
yeah, I'm not, you get a bid date for him on like December 13th, okay?
Yes, Your Honor.
Thank you. Diego Morales,
I didn't have it.
you didn't have him? You don't have him?
He's here, Judge.
No, he said he was. He's released. They thought he was in jail.
No, he's here.
Diego Morales.
Oh, yeah.
Commonwealth versus Diego Morales, 24 CR 0038. Are you Diego Morales? Good morning. Stand behind the podium there. You born in 1996?
Yes, sir.
Last four digits, social security number 5466.
Yes, sir.
We're here for a pretrial conference. What does the Commonwealth have to say?
Your Honor, we need one more pretrial. Mr. Garrett and I have discussed this case and he's going to furnish me some evidence and I want to review.
What's the charge here?
This is the possession case that Mr. Cottle had. Mr. Morales showed up to court about 4 times without an attorney. So I'm not going to object to giving one more pretrial.
Okay. December the 12th. What's your negotiation date?
5th at 9 o'clock, December 5th.
You want him here on that day too?
No, I may have looked at the wrong
I think
calendar.
it's December 6th.
December the 6th, I'm sorry.
You want him here on that day too?
Yeah, December the 6th at
Then you're
9.
gonna be here December 6th for negotiation and your next court date's December 12th. Both of those are conditions of your bond, Mr. Morales, okay?
Yes, sir.
Yeah. Charles Muse. Commonwealth versus Charles Muse. Are you Charles Muse?
Yes, sir.
Good morning, Mr. Muse.
Good morning.
Were you born in 1976?
Yes.
Last four digits, social security number 7778.
Yes, sir.
You're on a probation revocation. What does the Commonwealth have to say?
Your Honor, Christopher Tomlinson, Special Prosecutor for this case. Your Honor, Mr. Muse has been charged with a couple of misdemeanors. So the Commonwealth would propose that time served would be a sanction for that, as long as Mr. Muse agrees to do a substance abuse assessment and follow recommendations flowing therefrom.
What's the underlying charge here?
It's the final lawful taking the class D level. Judge, I don't know anything about the case. I just represent him for the revocation.
You mean the pretrial diversion that he's on, Judge?
Yeah,
It was a theft by unlawful taking, he entered into on January 18th, 2024.
but the restitution, the reason I'm getting back to it, was there any restitution required in the case?
I don't believe so, Your Honor.
There wasn't.
I don't remember any restitution, sir.
So how long has he been in jail?
63 days, 64 days.
Judge, he's been in jail
So you're
since,
saying that'd be the sanction on him, is what you're saying?
Yes, sir.
Okay. What about probation and parole? What do y'all know about him?
Your Honor, he was pretty compliant with me. The only thing I would ask is, the medical marijuana that that ceases.
Yeah.
I think that's the problem.
Until the legislature acts and puts something in place, you can have a medical marijuana card in the state. But, you know, I'm not so sure about having marijuana. And then you have to prove that you went out of state somewhere and purchased it legally. So,
That's fine.
yeah, you think you can hold off on that? We'll all be, until the legislature in its wisdom goes this next step, okay?
Sounds great with me.
Okay, I'll do a release on him. Thank you very much. Do you have any further business?
I don't,
You
Your
may
Honor.
be excused. Have a
Thank you,
safe
sir.
trip. Thank you. Joshua Perry. Commonwealth versus Joshua Perry, 22 CR 0033. Are you Joshua Perry?
Yes, sir.
Good morning.
Good morning.
Were you born in 1991?
Yes, sir. I
Last
would.
four digits, social security number 5880.
Yes, sir.
You're here on a motion for shock probation. Would you make your motion?
yes, Your Honor. If the court recalls, we were previously before the court on the motion for a shock probation. And I believe that the court took testimony back on, I think in July or August, Your Honor. However, at that time, Mr. Perry was coming up for parole consideration in October. The court passed it to November. If Mr. Perry had made parole, shock probation was moot. Unfortunately, Mr. Perry did not make parole. They blocked him until July of next year. So we would ask the court to grant shock probation in this case.
The Commonwealth have to say about this.
Your Honor, I'm
If you want
opposed.
to come around, y'all move to the left.
I'm opposed for the reason he was originally revoked on his probation. He absconded in July of 23 and he was revoked in April of 24. So he was absconded for about 7 or 8 months at least. And
How much time does he have left?
he's got serve out 2 years and 9 months, but he meets the parole board in another 7 or 8 months. But I've got filing cabinets full of each county people in NCIC where they abscond. He's had his chance.
What was the underlying charge?
It was 5 years on fleeing and evading in first degree.
Okay. And Judge, I don't know anything about the underlying case. I just stepped in for the revocation proceeding and then, of course, for the filing of the shock probation. Mr. Perry would have work in construction, as the court has previously heard in testimony. And would you be living here in Monroe County?
No, be Simpson, Simpson.
In Kentucky? Okay. And he would have, he would be living in Simpson County.
You're the first person I've ever seen that the parole board has flopped for something like this. There's bound to be some underlying situation. Do you know anything about this case? Probation, parole, anything about this case?
Your Honor, I don't know a whole lot. I know.
Come around here a little bit.
I'm not sure, did the Kentucky Pro Board flop him or was it Tennessee? Kentucky. I don't know. We can't see those notes on their decision on that. So I'm not sure. I don't know if he had some pending charges in Tennessee, maybe that they seen. That could have played a factor in that. Of course.
What are the charges that are pending in Tennessee?
I don't have no pending charges in Tennessee, and that's why I got absconding here is because I was serving my time out in Tennessee.
What do you know about that, Mr. Stockton?
I don't know. But we don't have any information from Tennessee.
Well, let me tell you what I want to do. I'm going to take this under submission and I want you to find out if what he's saying is true, that he was incarcerated down there during the time period that he absconded here. And if he is, I'll take a look at it. But if that's not so, then I'm going to deny it. Okay, so I think that's a fair treatment of you, okay? But what Mr. Stockton says is valid. If you just absconded without any valid cause, then I'm not going to do that. But if it is, so if you'll provide that information, provide it to defense counsel and the Commonwealth. Thank you very much. Rush Garrett. Rush Garrett.
He's in jail.
At the jail, Your Honor.
Okay, we'll get him online here. Robert Simpson. Commonwealth versus Robert Simpson. 22 CR 00107 and 24 CR 0079. Are you Robert Simpson?
Yes, sir.
Good morning. Were you born in 1991? Last four digits, social security number 5031.
Yes, sir.
What does the Commonwealth have to say in this case?
Your Honor, we have, encountered a problem in this case. The, drugs and the alleged drugs that were confiscated by Deputy Gerald's were taken to the Monroe County Post Office. And they have never been found in transit. We have the postal inspector looking into this. And so I don't know ultimately what's going to be the resolution of the case. Ms. Brown and I tendered an order to have Mr. Simpson released on home incarceration for the temporary time until we can see what's going to happen. I thought that would be.
Was that the reason he was going to get revoked because of this additional charge?
That's correct. Now, even if the drugs are not found, there may be a trial anyway because he made certain admissions when the police officers arrested him. So I'd have to look at that and see what kind of cases left if they're ultimately not found.
Where is Mr. Simpson going to be located as far as?
Judge, he would be living here in Monroe County, on.
You have a particular address, and don't read
Yes.
it out loud, just as
Yes,
Commonwealth
it
aware of
would
what
be
it
the
is.
address that, sorry, Judge, I did not mean to speak above you.
Sure you did.
It would be the address that probation has on file.
Fine, come.
Okay.
Okay, you have a transfer? Okay.
ROR up to that address, is that correct?
With a
Do what?
monitor.
It's 20,000 unsecured is what the agreed order says.
20,000 unsecured. Okay,
Yes, Your Honor.
clerk approved surety.
Home incarceration.
Yes.
And then we'll redocket it. You want to go ahead and redocket it in January,
Be fine. Your Honor.
January the 16th. And then you don't have any idea what your negotiation day in January is, do you?
It would be the 3rd, Your Honor.
January 3rd is your negotiation date, and January 16th. Both of those are conditions of your bond. Do you understand? Okay. Don't be out gomming around. Okay, thank you. Rebecca Vibbert.
She's still at the jail as well, Your Honor.
Still at the jail. And Chandra Warren. Commonwealth versus Chandra Warren for sentencing. Are you Chandra Warren? Good morning. You were born in 1980?
Yes,
Last four digits is social security number 8790.
yes,
You're here today for sentencing.
yes, sir.
Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Is it substantially correct?
Yes, sir.
Is there any reason this lady should not be sentenced
No,
today?
Your Honor.
On a plea of guilty possession of controlled substance, first degree methamphetamine, the defendant shall receive 3 years, serve 76 days in jail with a balance probated for 5 years. She will receive credit for time served and be released upon final sentencing in November today. She got her time in. What are the court costs in this case?
$165.
$165. You need some time to pay that.
Yes, sir.
Okay, I'll let you pay $30 a month, first payment 30 days from today, okay? I'll send the order over to you.
Thank you, Your Honor.
Probation and parole need to go over there and arrange when you're going to meet with him, okay? Commonwealth versus David Bridges. What's the deal with this, him being on rehab and not being transported? I'm sure I agree to that. I don't know.
Well, the problem was we had an agreed order. And for some reason, either I didn't get the second page or I didn't attach the second page and I sent it to Ms. Thompson back in October. Didn't realize till 2 days ago that all the order wasn't sent. Mr. Bridges owes about $25,000 to the state for child support. Mr. Bridges, during most of the time that has accumulated, has been in prison. So we agreed the last time he was in court to send him to the rehab and let him pay $50 a month. And that's what that agreed order says. So if the agreed order is entered, I don't see any reason to redocket this case.
The only issue with the agreed order now is that when I was notified that he had a bid date and was ready to go, judge said an ROR bond.
Well, that's
And that order sets an unsecured 20,000.
whatever bond he's supposed to say. As long as he's in rehab paying his $50 a month, the Commonwealth is satisfied.
That order,
Yeah.
because I don't think there's any order entered setting out the payments, right?
Okay. Well, it's in that agreed order.
Not the agreed order sets at 20,000 for the cash bond. He's out on the ROR, so if I do a subsequent order to the cash bond, I'm afraid something might happen.
I'd ask just to continue it generally.
Okay, y'all submit the amended order. Okay. James Bristow. For sentencing. Commonwealth versus James Bristow, 24 CR 0033. Are you James Bristow?
Yes, sir.
Good morning, Mr. Bristow. Were you born in 1990? Last four digits, social security number 8640. Here for sentencing. If you had an opportunity to look at the pre-sentence investigation report done by Probation Pro, is it substantially correct?
Yes, sir.
On plea guilty to trafficking, controlled substance first degree, you shall receive a sentence of 5 years, serve 60 days, the balance probated for 5 years. Now, how many days does he have in now?
Your Honor, on the record, last month, I believe Mr. Stockton had agreed to allow him to do that as home incarceration because he is employed. You are on the ankle monitor.
How many days does he have in?
Your Honor, I don't know exactly how many. I know he's been on the
Well, he
ankle
needs to meet
monitor.
with Probation Pro and y'all can calculate how many days, and if he's got the 60 days, I'll sign an order taking the ankle bracelet off. It's the reason I'm asking. If he's complying and working and not causing any problems, if he's got his 60 days in, we'll take that off. How about the court costs in this case? 155, 65. I'll let you pay that $30 a month. Your first payment's due 30 days from today. Yeah. Meet with Probation Pro. Stephen Chavez. Active warrant.
He's in custody on a chance to serve. So. He just showed her here this morning.
Even should end.
If I could even.
Commonwealth versus Stephen Chavez. Are you Stephen Chavez?
Davis, yes.
Chavis?
Yes.
Okay. You want to come around? There's an active warrant here. We're here for the purpose of arraignment in 24 CR 0087. Mr. Chavis turned himself in this morning. Is that correct?
He come in for
Mr. Chavez, the grand jury of Monroe County has charged you with operating a motor vehicle under the influence, vehicular homicide, reckless driving, criminal mischief in the first degree, and possession of marijuana. You understand those charges?
Yes.
Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
And I'm signing a reciprocal discovery order here, Mr. Chavis, that says the Commonwealth provides you information they have to help you prepare for your defense. Is there forensic evidence, Mr. Stockton, or other
The
things?
labs are already have been returned, so the only thing would be if they want to look at a reconstructionist or something, because we've already done ours, the can't speak yes.
Well, I can set a negotiation day on this for December the 6th at 9 a.m. And the next court appearance is the 12th, and by then you shall have probably digested the discovery to see where you are and whether a trial date can be set. What's the bond that I've set on this? What it,
Got any paperwork from, if you was just taking custody out.
well, it's on the warrant. What's the bond on the warrant? Okay, we'll leave that there until we find more about this, okay?
Yep.
Thank you. Ricky Emberton. Hello. Commonwealth versus Ricky Emberton, 24 CI 0071. Are you Ricky Emberton? Good morning. Were you born in 1963? Last four digits, social security number 0973.
Yes, sir.
We're here on 24 CR 0071. It says a motion for bill of particulars. What does the Commonwealth have to say?
They've been answered, Your Honor.
What do you,
Yeah, they sent me a letter, Judge. We're ready to go in the morning.
anything else? That it?
Motion.
Okay.
Thank you, Judge.
Yep. Tiffany Etheridge. Commonwealth versus Tiffany Etheridge, 24 CR 0085. Are you Tiffany Etheridge? Good morning.
Morning.
Were you born in 1981?
Yes.
Last four digits, social security number 5124.
Yes, sir.
Okay, we're here at a pretrial conference on 24 CR 0085. What's the Commonwealth have?
Your Honor, we have some discovery issues in this case. Can we set this for a pretrial in January?
January the 16th. And what's the negotiation date?
January 3rd.
January 3rd. Here to be January 3rd at 9 a.m. and January 16th. Both of them, Ms. Etheridge, are conditions of your bond, okay?
Yes, sir.
Thank you, Your Honor.
Joby Grace, yeah. Joby Grace. Commonwealth versus Joby Grace, 24 CR 0061. Are you Joby Grace? Good morning. Were you born in 1972?
Sir.
Last four digits, social security number 6969.
Sir.
Okay, we're here on a pretrial conference. What does the Commonwealth have to say?
We're gonna enter a plea, Your Honor.
Felony, please.
Felony plea, okay. This motion we see has been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
This is plea freely and voluntarily given.
Sir.
Are you the same person that we just identified in 24 CR 0061?
Sir.
Is your judgment impaired today in any way? Are you satisfied with the advice of your attorney?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you? Feel like you're fully informed?
Sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I'll go over those rights and ask you to understand them. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor. The right to appeal this matter to higher court if you lose, and the right to part of the Commonwealth proving on a reasonable doubt that you're guilty of the charge against you. Understand that by entering a guilty plea today, you give up all those rights. Understand that? I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting any recommendation, I will await the pre-sentence investigation report done by probation parole. In the event that I do not accept the recommendation and decide to impose harsher punishment, you have a right to withdraw your plea, go to trial. Do you understand that? What is the Commonwealth's recommendations for Joby Grace?
Mr. Grace would plead guilty to theft by unlawful taking over $10,000, receive a sentence of 10 years. On burglary third, he would receive a sentence of 5 years. On facilitation of the criminal syndicate engaged in organized crime, he would receive a sentence of 5 years. The 2 5-year sentences will run concurrently for a total of 5 years, but be consecutive to the 10-year sentence for a total of 15 years. He would pay restitution in the amount of $45,000 jointly and severally with co-defendants Jody Murphy, Michaela Pettigo, and Damian Hurd at a rate of $250 a month, with first payment being due 30 days from the entry of this plea and all subsequent payments being due on the same day thereafter. Restitution subject to a 5% clerk's fee in addition to the $45,000 restitution, and shall be added to each monthly payment of $250. Probation shall continue until restitution is paid in full. He'll have no contact with the victim or the victim's property. He'll receive credit for time served. He'll obtain and maintain gainful employment, and all other evidence in this case will be destroyed.
So what you agree to? What's the court cost in this case? Okay, we'll address that at sentencing. Are you entering this plea because you did commit the acts charged in the indictment as amended?
Yes.
Doing so your own free will?
Sure.
Knowing your constitutional rights explains it's still your desire to enter this plea and allow the court to fix your punishment. You understand that in the future, if you have any other felony convictions, they could be enhanced into persistent felony offender law because of this plea. Is that your signature on the document? You have a plea agreement?
Yes, sir.
I'll accept the plea, order pre-sentence investigation report, sentencing on December 12th. And was this a probated sentence, Mr. Stockton?
I'm sorry, Your
This
Honor.
was a probated sentence.
That's correct.
Okay, so I'll allow him to remain free while the pre-sentence investigation report is done. Meet with probation and parole officer.
Thank you, Your Honor.
Yeah, thank
Your Honor,
you.
that concludes my business.
Have a safe journey and happy Thanksgiving to you.
Thank you, sir. You too, sir.
Devin Green. Commonwealth versus Devin Green, 24 CR 0035. Are you Devin Green?
Sir.
Morning, Mr. Green. Are you born in 1992? The last 4 digits, social security number 7447. Here for pretrial conference. What does the Commonwealth have to say?
Your Honor, Ms. Hill has receipts showing where Mr. Green paid approximately $5,200 to child support office. This needs to be filed with the clerk, and once it is, I'll be tender an order to dismiss the case.
Well, good work, Mr. Green. So if we get that, we'll release it and you can be on your way rejoicing, okay? I'll docket it again for next month. And then you can just remove it by docket. It's already been paid though, you say.
It's been paid. She just needs to file a copy of the receipt.
Okay.
with the clerk.
Well, then once that gets filed, we'll do the order of dismissal. Dixie Harder. Dixie Harder. Mr. Stockton, do you know anything about Dixie Harter?
Well, she's been served. Has she been served? I don't know anything about her.
Has Dixie Harter been served?
I thought she'd probably have acted.
Oh, are you looking at that? See if she's been served?
Yeah, she was served.
We'll put her in NCIC here.
So it was served on the 18th of October and she posted a $25,000.
Who's on the surety? We'll take a look at
Well,
that.
I've asked the clerk to email me a copy of the surety bond so I can take appropriate action.
That'll be fine. There's already a warrant out, I guess. Do a bench warrant for failure to appear without bond. Jody Murphy.
That's my client. She had COVID. She's on her way here. I told her, she's been in contact with me and she told me the clerk's office too. She should be
I'll
here.
pass over her to the end of the docket.
Thank you, Judge.
Michaela Pettigo. Oh. How do you pronounce your first name? I got it right. Are you Michaela Pettigo?
Yes, sir.
Good morning. You were born in 1997.
Yes, sir.
Last four digits, social security number 0940. We're here on 24 CR 0059 for a pretrial conference. You are Linda Myers, is that correct?
Yes, sir.
What's the Commonwealth have to say in this case?
A diversion plea, Your Honor.
Motion's been tendered, says you wish to enter a guilty plea today, is that correct? Are you currently under the influence of drugs or alcohol?
No, sir.
This is being freely and voluntarily given. Are you the same person that we just identified in 24 CR 0059?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? You feel like you're fully informed about your case? You understand you don't have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to go over them and ask if you understand. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury. Right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. And the right to require the Commonwealth prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that? And I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided law. I don't have to accept the recommendation in the event that I don't accept the recommendation and decide to impose a harsher sentence. You have a right to withdraw your plea. I'm going to ask you some qualifying questions. Have you previously been diverted in the past 5 years? You had a pretrial diversion in the last 5 years? Have you had any felonies in the past 10 years?
No, sir.
Are you presently on probation anywhere? Are you on probation? Well, you're hesitating with me here.
I'm sorry,
Just speak up.
I'm
You want to
nervous.
step away and ask her if she's on probation?
I'm just nervous.
Well, that's
I'm sorry.
okay. You know, we'll get
No,
through
sir, I'm
this.
sorry.
You know, I just, people get nervous sometimes when they're not being truthful, or they just get nervous either way, okay? So I understand. You understand that, if you fully complete a diversion program, the charges could be dismissed, pretrial diverted, and you get your record expunged. You understand that? You understand if you successfully complete the program, if you don't successfully complete the program, it'll be brought back in front of me. You understand that? And you could be sentenced to be a convicted felon. You understand that?
Yes, sir.
Okay, come over with a recommendation. Step to your left there.
Yes, Your Honor. Upon a plea of guilty to theft by unlawful taking or disposition less than $10,000, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to burglary third degree, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to facilitation to criminal syndicate engaging in organized crime, the defendant shall receive a sentence of 5 years. The 3 5-year sentences shall run consecutively for a total of 15 years, pretrial diverted for 5 years, supervised. The defendant shall pay restitution in the amount of $45,000 jointly and severally with co-defendants Joby Grace, Jody M. Murphy, and Damian Hurt at a monthly rate of $250 per month, with first payment being due within 30 days from the entry of this plea, and all subsequent payments being due on the same date thereafter. Restitution is subject to a 5% clerk's fee in addition to the $45,000 and shall be added to each monthly payment of $250. Any amount of restitution owed shall be due in full on the 58th month of pretrial diversion. Supervision shall continue until restitution is paid in full. The defendant shall have no contact with the victim or victim's real property. The defendant shall receive credit for the time served. The defendant shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style case forfeited and destroyed in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Are you pleading guilty because you did do the acts charged in the indictment?
Yes, sir.
Okay. Doing so your own free will.
Yes, sir.
Knowing your constitutional rights, it's still your desire to go forward. Plead guilty to the charge and allow the court to fix your punishment. Is that your signature on the document?
Yes, sir.
Okay. Okay, let me ask about this $250 a month. Is that each one of these defendants are paying $250?
Yes.
So collectively, they're about $1,000 a
If
month.
they all pay like they're supposed to be, $1,000 a month, they've been paid out for 4 years or less.
Okay.
And I just put that 58 months in there in case somebody doesn't pay, and we have to go back and see what we need to do.
Okay, you need to meet with probation pro. I'll sign it, okay?
Your Honor, that's all that I have for today, if I may be
Yeah,
excused.
absolutely. Have a safe Thanksgiving. Jose Keanu. Jose Keanu. Madam Interpreter, you raise your right hand, you solemnly swear or affirm that you will properly translate proceedings this court to a correct manner, and you've previously been recognized as a translator in the courts of Commonwealth of Kentucky.
Yes.
Okay, I do. Commonwealth versus Jose Quano, 24 CR 0031. Are you Jose Quano?
Yes, with it.
Okay. Were you born in 1984?
Yes.
Okay. You have a social security number.
No. 84, you said.
Do what?
You said 84,
Yeah.
correct.
We are a pretrial conflict. What's the Commonwealth have?
This matter is set for trial December 17th.
What's the charge?
Bribery and terroristic threat emanating from, I think, a DUI.
You tried to negotiate this, did you?
I've tried, Judge, and to be candid with the court, but for some collateral issues, I think the case would be resolved. The problem is there won't some jail time, which he wouldn't mind really having to do that, but under the circumstances of INS coming in and deporting everybody all the time now and putting the holds on them, I think the punishment would end up being a lot greater for him than what we were.
You lost me somewhere in that. I don't understand what you're saying. What's Commonwealth have to say? Come around.
He's afraid that if he does serve the jail time, he'll be deported.
That's right. They've been putting detainers on everybody, Judge, and shipping them out. He's got children
That's
there.
above my pay grade.
Well, I understand.
It's above my pay grade.
And I mean,
The issue in this case is he's going to have a trial.
yes, sir.
And if you're, if you're telling me that the deportation situation is such an issue that he doesn't want to advance this, then I'm wondering if he's a flight risk.
No, I mean,
Are you following what I'm saying? I mean, if
Oh,
he's
sir,
gonna make
that-
it,
that
if he's gonna make his decision predicated on whether or not he feels like he's gonna have to serve jail time, I don't understand really.
Well, if he enters a plea, it's my opinion from advising him that I think they'll put a detainer on him and he'll be shipped out. He's got a good job here. He's married. He's got children here that he wants to support. If he goes to trial, at least then he has an opportunity to possibly come out from under it. I don't really think much
He
on
found not guilty. Is what you're
Yes,
saying.
sir.
What, the charge is what now?
Bribery, the problem in the case is, I think Mr. Kenyano was intoxicated and he made a lot of statements about the officer and the officer's family and the officer wants dead. And I think that's where we are, just to put it blunt.
Yeah, I don't think any of us is really too concerned over the bribery, the felony. It's the terroristic threatening that's holding us up.
Statements he made.
Yes, sir.
Who is the officer?
Mr. Henry, Officer Henry.
We've got one more pretrial between now and then. I'd like to, at least, I'm going to continue to talk to Mr. Stockton and see if we can work something out. I don't know if it's possible or not, but
The next pretrial would be
December the 6th.
December, the negotiation day would be December the 6th. And the next pretrial is December 12th, right?
Yeah, that's correct.
Okay, if you make sure we have an interpreter back on that day here. I really don't, I want to make sure that we don't treat this gentleman any differently than anyone, and I'm not saying you are, okay? I just want to make sure of that a decision about him is not predicated on whether someone might subjectively think that he should be deported or not. You see what I'm saying?
I do, Judge.
Yeah, I want to be, because
I thought that was the case. I'd already reported him and had him shipped.
But I understand that, but I think if you talk to the officer about it and see, you know, what we can do. And
But whether he's here legally or illegally, I think he has to comport with the law.
no doubt about that's,
Sensibilities.
he should not receive any more nor any less treatment.
I agree with that, Judge.
Okay. Okay, we'll see you on those dates.
Thank you.
Commonwealth versus Robles.
You want Jose out here too, Judge?
Well,
Actually, he's on Zoom. But we can take her up first.
Ms. Robles, remind me again for the 15th time how to pronounce your first name.
Fatima.
Fatima. I'm sorry. It
It's
doesn't.
okay.
I don't see you anywhere to call you by that name but here, so, you know, good morning. This is Commonwealth versus Fatima Robles, 24 CR 0015. Ms. Robles, were you born in 1996?
Yes.
Last four digits, social security number 6935.
Yes.
Okay, what does the Commonwealth have to say in
Your
this?
Honor, we have all the lab results and they've been furnished to Mr. Garrett at this time.
We've got a mediation.
Is there,
And we have asked the court,
is there, the companion case is what?
Jose Robles. And he's in Barron County Jail.
Yeah.
I think it has been.
I was waiting for today. I should address it with Judge.
yeah, we've asked the court to mediate this case.
No, the mediation order's being entered. I'm talking about the agreed order on the ankle bone.
Oh, right.
Mediation order's being entered.
Okay. You know, Mr. Garrett asked for an agreed order removing her from the ankle monitor. I've discussed that with the family. I would prefer being off the ankle monitor because she's getting day credit for every day if she needed sentence. So I prefer her to be off. I think she's a flight risk.
Well, that's.
Since you had her, she won.
You want to start? So definitely she's gonna get credit then.
For the days she's
I
on,
don't want to get any more credit. That's what I'm saying. She keeps accruing
when
credit
she's
every day
on
she
the
goes.
ankle monitor, what he's saying, she does get credit.
Was it? If
When
he's
she comes off the ankle monitor, she doesn't get
That
credit.
is correct.
Thank you.
If the court wants to keep on the bracelet, I'm.
I
fine
don't
with
really
that,
care. I don't, Commonwealth says the Commonwealth doesn't care. It's your client's decision.
Be taken out because I think it's, to me, I just asked that she be taken out.
Okay, I'll take her off, you know.
Yeah.
Okay, now you want her here when?
When will the media, I guess we'd need to set this maybe in January.
January the 16th will be your next court date. What's the negotiation day in January?
The third.
January the 3rd for negotiation, January 16th, both of them are conditions of your bond, okay? And she makes arrangements with you to come off of it, okay? Gerald Ryan.
At first, Judge, he said she wouldn't get credit. Now that she's getting credit, so we had confirmation on it, then we may have decided differently.
You just need to think these things out, Mr. Garrett.
You said earlier that she would not.
Commonwealth versus Gerald Ryan.
No.
Are you Gerald Ryan?
Yes, sir.
Okay, good morning, Mr. Ryan. Were you born in 1957?
Yes, sir.
Last four digits, social security number 8954.
Yes, sir.
We're here for a pretrial conference. What's the story?
Your Honor, I need to do some work in this. I need some additional counts to go to the grand jury.
Okay, let's,
We've got those phone records that are still out too.
okay,
They're not even.
wait just a second here. So are there additional charges? Why don't you, if you have additional charges that you might go to the grand jury on, why don't you present those charges to counsel before December 2nd? And you might be able to agree to go forward by information. Okay, that way we can move it. And so you'll be here on December 6th for negotiation and December 12th. And what they're saying, sir, is they might have additional charges, but by December 6th, your attorney will be informed about what those charges are. So you might be able to wrap all this up. You understand what I'm saying?
Yes, sir.
Okay, thank you very much. December 6th and December 12th, both of those are subject to the bond. Jonathan Scott. Commonwealth versus Jonathan Scott. 24 CR 0064. Are you Jonathan Scott?
Yes, sir.
Good morning, Mr. Scott. Were you born in 1974?
Yes, sir.
Last four digits, social security number 0956.
Yes, sir.
Here today on the pretrial conference, what does the Commonwealth have to say?
Well, I'm kind of waiting to hear from Mr. Scott and defense counsel, because my understanding was he was going to go to long-term treatment. He has a lot of time on the shelf. And if he's convicted of these charges, he's going to go to prison for quite a while.
What are the charges?
This is a charge of possession or trafficking, where there was approximately 3 grams of meth found on the floor at Walmart out here,
How many grams?
about 3 grams. So I'm about to the point to set a trial.
Judge, we have been negotiating this case, and my office is in the process of arranging treatment that would send Mr. Scott to a residential program. And it would become part of his bond conditions at that point. I do not have a bed letter in hand today, but I expect that I would be able to tender one to the Commonwealth within the next couple of days. I would ask that the court would place this on the December negotiation, well, pretrial date. I am not available for the negotiation conference, but I will be in contact with Mr. Stockton prior to.
December 12th.
Yes, thank you, Your
And
Honor.
it either be resolved that day or I'll set a trial date.
Yes, Your Honor, I understand.
Chad Shirley. Commonwealth versus Chad Shirley. 24 CR 0029. Are you Chad Shirley? Good morning.
Morning.
Were you born in 1990, Mr. Shirley?
Yes, sir.
Last four digits, social security number 4625.
Sir.
We're here today, 24 CR 0029 for a pretrial conference represented by Mr. Bell. What does Commonwealth have to
Now that
say?
I've got one syndicate case resolved, I can work on this one. Can we have one more pretrial?
Have a negotiation day on December the 6th
Yes.
and a next pretrial on December 12th. Okay, both of them are conditioned to your bond. Ashley Smith.
No, set it for December.
Commonwealth versus Ashley Smith. Are you Ashley Smith?
Yes, sir.
Were you born in 1984?
Yes, sir.
Last four digits, social security number 9112.
It is.
We're here on 24 CR 0067 for a pretrial conference. What does the Commonwealth have to say?
Well, counsel defendant wants to see if there's any body cam in this case to review, and we're going to try to see if there is and furnish that.
And Judge, if we can place this on for December, I think at that point we can either resolve or trial.
You're not going to be there for the negotiation.
I will
day?
not be there for the negotiation conference, but I'm gonna speak with Ms. Smith, make sure we got, double check we got good contact information. And I'll be in contact with Mr. Stockton.
December 12th, the next
Thank you, Your
court
Honor.
date. December 12th.
Speak with you.
Christopher Stillwell.
For just a minute.
Commonwealth versus Christopher Stillwell. 24 CR 0012. Are you Christopher Stillwell?
Yes, sir.
Good morning.
No.
Were you born in 1975?
Yes, sir.
Last four digits for your social security number 6497.
Yes,
You're here for the purpose of sentencing. Have you had an opportunity to look at the pre-sentence investigation report under probation parole?
Sir.
Is it substantially correct? Mr. Bell, is there any reason this gentleman should not be sentenced?
Judge, the only objection we had to the pre-sentence investigation was the number of days that he was given. I've done ask probation and pro to look into that to try and correct that.
They can administratively, you can administratively appeal that. And if you have some disagreement, you can bring it back to me.
Yes,
correct?
sir.
Okay. Upon a plea of guilty to trafficking and controlled substance, first degree, greater than 2 grams, the defendant shall receive a sentence of 10 years, serve 180 days in jail with a balance probated for 5 years, supervised, receive credit for time served. How many days does he have in now? Does he have over 180 days in now?
Your Honor, I think on the PSI it was 6 days.
How many?
There's only 6 days on the PSI, but he's thinking he's missing a month. Is that correct, Your Honor?
There was 6 on the PSI. That's what we're objecting to, Your Honor. We
Now,
believe
what's the
that.
court cost in this case?
$185.
You need some time. I'll let you pay that at $50 a month, starting 30 days after you're released, okay? You're in the custody of the jailer.
As part of the agreement, I believe they worked out home incarceration on the 180 days.
Yeah.
Let me-
It's not in the
That's my
agreement.
understanding,
You what?
because he had a job. I'm trying to remember where he was working.
Former tree service, Glasgow.
Yeah.
We done that up in Albany.
Yeah.
Or I'm sorry, Burkesville.
Let me get the offer. I'm sure that's correct. I just need. Because I remember talking to Mr. Stillwell that day.
That's right.
You want to say, sign up with this gentleman here? Can you sign him up now? Benjamin Tooley. Meet with the probation, well, you need to meet with the probation parole officer right there. Benjamin Tooley. Commonwealth versus Benjamin Tooley, 24 CR 00020. Are you Benjamin Tooley?
Sir.
Good morning.
More.
Were you born in 1987? Last 4 digits, social security number 2174. Is that correct? Okay, we're here on a pretrial conference. What does the Commonwealth have to say?
Judge, I was supposed to have done an agreed order on this, passing it till February, and I didn't do it.
You know, we're up here about every month, Mr. Tooley. That's the case in Allen County. He's on probation, doing well, working, so
What's the charge here?
possession, yes.
February the 13th, you want him there for negotiation day or just the February 13th?
I just said for February, because I doubt Mr. Vale will have the Allen County resolve the case, but then.
February the 13th, you'll be back here. You're released on the same conditions of bond, okay?
Thank you.
Jeremy Turner for arraignment. Are you Jeremy Turner?
Yeah.
Good morning. You represented by counsel? You have an attorney? Have you filled out an affidavit? Hey, can you afford an attorney?
No, sir.
You come over here and fill out an affidavit. With her.
Yeah.
Do you have a public defender in district court?
Yeah.
Okay, I'll continue that appointment. Here with the purpose of arraignment. You have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with assault, fourth domestic violence. You understand what the charge is. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Signing reciprocal discovery order in this case. Scheduling you for a negotiation on December 5th, and the next court date is December the 12th. No complaints about the bond. You remain on the same bond, okay? Okay, now there was someone that was on their way here that I passed over. Well,
Yeah.
well, I'll issue a bench warrant for her, and if she comes here, I'll withdraw it. If she doesn't, she'll be arrested, okay? You can wait around for her if you'd like. We have 11 minutes before we go online with Allen County. Is there anyone else here in the courtroom that came to appear today?
We have Rover on.
Roder is on.
Keith Rose.
Okay, Commonwealth versus Keith Gross. Roder, if you'll turn your camera on, thank you very much. Are you Keith Gross?
Yes, sir.
Good morning.
Morning.
We're here on pre-trial conference on 19 CR 0053, 18 CR 00160, and 21 CR 0061. Department of Public Advocacy.
Your Honor, Mr. Gross.
If you'll come up to the microphone here.
Your Honor, Mr. Gross had conflict counsel through our office. If I could have just a few moments to figure out,
Andrew Rhodes.
if we're gonna have a few minutes to try to contact him.
We've not had much success getting in touch.
Your Honor, I've tried to call him numerous times and can't get a hold of him or get a call back.
I believe Mr. Gross.
I believe you. You just hold tight right there. We'll see if we can get him online. I'll just remove the case.
I will reach out.
Thank you.
Wait just a second. I'm not going to do it yet. I'm going to ask what his side.
Okay.
I'll go reach out to my office, Your Honor. See if we
Okay,
can
just
get
turn your microphone off, but stay online and we'll be right back when we get in contact with this guy. What kind of notice was sent to Mr. Gross?
It's in her plea. A pre-trial conference.
Yeah, we negotiated out a plea a long time ago. We sent a notice and emailed him, but we just never heard from him.
September, that's when I emailed the paperwork.
Yeah, but
And then we did it again this month.
he emailed the paperwork in September. Nothing.
Mr. Gross is a state prisoner, is gonna be there for a while.
I'm just trying to clean up the rest. of the
Okay,
state.
here's what I'm gonna do. Don't you worry about calling him. I'm going to go ahead and schedule this for December the 12th for sentencing. And
He's got your report.
Yeah, he's not entered it yet.
I mean, for entering a plea, December 12th. I'm removing, the counsel for not appearing today. And I want to issue a contempt order to have him to come here on December 12th himself to show cause why he should not be held in contempt and given jail time. I'm tired of these people, leaving these people in jail, not contacting them. These are human beings. They deserve to be treated appropriately. To have somebody there, there's nothing more inappropriate than a court system that tries to administer justice and is so much disregard. So issue a show cause hearing for him to be here the 12th, and please get counsel for this for Mr. Gross and have him call Mr. Gross. Mr. Gross, you're excused. Somebody will be over to see you with a new lawyer, okay?
Thank you, sir.
Okay, let's go off the record for 7 minutes here. What did I push you? Do I have to push something?
We don't know.
We're going to Allen County. Okay, let's go back on the record. Go back on the record. Let's go to Allen County Detention. Allen County Detention, are you on there?
Yes.
Could you turn your camera on, please? Commonwealth of Kentucky versus Kayla Spivey. Are you Kayla Spivey?
Yes.
Were you born in 1992?
Yes.
Last four digits of your social security number, 9656.
Yes.
Your attorney is here present in the courtroom. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
Substantially correct?
Yes.
Is there any reason this lady should not be sentenced, counsel?
No, Your Honor.
Judge, this is the one with the victims impact statement.
Okay, we have a victim's impact statement to be read. That's what I just said.
Yeah, one of them is set aside.
Well, they need to come in here.
You're doing this. And you just let anything do that, like, it's safe, so.
You need to go out and get your people here.
Just say. That's great.
Get behind the podium right here, please. Okay. Good. Good morning. Would you identify yourself, please?
My name is Jessica McPherson. I'm going to be reading on behalf of the family of Austin Copus.
Okay, please proceed.
The day I had to bury my child was the hardest thing I've ever done in my life. The thought of losing one of your children never enters a parent's mind. I don't even know where to begin to tell the court of the impact of this senseless and brutal death of Austin and what it has taken on me as well as our entire family. Today and every day, I am mourning the loss of him. To wake up every morning knowing I will face another day without him is a feeling not like no other. Unless you have experienced the loss of a child through the hands of someone else, you can never even begin to imagine the worst pain and heartache for a parent. The feelings of utmost shock and sadness continue to linger in my heart every single day. My days are now spent going through a constant cycle of emotions. I honestly don't know if I'd be standing here today if not for the support of my family, friends, co-workers, and many, many prayers throughout our community. The one thing that has never left my mind is how Austin must have struggled to live while others had no regard for his life. No human being deserves such a horrible death. To have died for such a senseless act just does not make sense. I cannot imagine how Austin must have been in shock and scared for his life. I am so sorry I wasn't there to help or protect you from such pure evil. Please always know I'll fight for you until my last dying breath. I feel like our family has gotten the worst sentence ever handed down. No amount of time for you or Edward could ever be enough. The dead cannot cry out for justice. It is the duty of the living to do so for them.
Thank you. Have another impact statement. Okay, could you identify yourself, please?
My name is Tasty Newport. I'm Trevor Cleary's sister. First, I would like to thank the court for the opportunity to read my victim impact statement. Though, to be honest, there could never be enough time.
Kleenex, you have a Kleenex for this. Her Kleenex over here somewhere. You have that over there to her. Take your time. Go ahead.
There could never be enough time given for me to tell you what a marvelous young man my brother was. He was just that, a marvelous young man who had dreams that he'll never get to chase, a future he'll never get to see, life he'll never get to experience. No one deserves to endure the terror and pain my little brother felt that day. He fought for his life so hard that you could see it even in his death. His knuckles were busted up, swollen, black and bruised. A defensive cut on his arm from trying to block being butchered by a knife. His head black and blue, accompanied by a huge knot, along with a hole left by a fatal gunshot. And last but not least, his throat had been cut from ear to ear. I know these things because I myself had to witness this graphic, horrific image that will forever be burned into my mind because I had to identify my 20-year-old little brother at the funeral home alone. Seeing him lying there, lifeless and cold, I couldn't help but think how, who, or why I could have done this to this baby. Only to learn that a sick man and a sick woman with children, siblings, and family of their own are the individuals guilty of ripping Trevor's life away. Let's not forget my youngest brother, Caleb, 19 at the time, solely finding my brother, our brother, the way Kayla and Edward had cold-heartedly left him, tied up like a hog, lifeless, surrounded by blood. Trevor and Caleb were a year apart, the exact epitome of my brother's keeper. Not separated since birth, in an instant, Caleb's world was torn apart. I understand it's a vivid tale, and I thought whether I should go into detail, as for all most of you know, his murder was just senseless and horrific. But I realized for you all to understand the gravity of the situation and the pain it caused, you'd have to know exactly what we think about, dream about, and live every day. Trevor had plans for his life. A loved football player, an aspiring diesel mechanic, and a devoted member of the Church of Christ. Trevor had a big heart, and to know him was to love him. He was selfless and kind and a very hard worker. He loved his family very much. He loved to lay and watch cartoons and eat junk food with his little sister Lainey. He loved playing Xbox with Caleb. He loved fishing with Dad and being petted by Mom when he was sick. And he loved to say, "Hey sis," all hours of the day. We lived in terror, our sense of security shattered in one day. We have been in a chokehold over this so long we forgot to live and some days how to breathe. It's been 4 long years, and I'm happy to say my 95-year-old grandmother, whom Trevor adorned and loved very much, along with the rest of our family, are finally getting justice. You no longer have that grip on our lives. We built back stronger and fortified the places you've shown us were weak. You forced us to come back stronger because we see that evil in the world, the evil people like you and Edward, are out there lurking in the shadows. I forgive you. I wish I could say my whole family forgives you, but as of today, I can say I forgive you. Because as it states in the Bible, If God is for us, who can be against us? In Romans 8:31. And it conveys the idea that no one can threaten the purpose God has for you, and that the only way we can experience defeat is if we give up. We will never give up. We will continue to live our lives to the fullest, and we will be happy just as Trevor would want for us. Trevor will forever be 20 and remembered as the most extraordinary young man this world will ever know. Trevor will be remembered as a warrior, and as for you and Edward, you will forever be remembered as murderers.
Commonwealth have anything else?
No, Your Honor.
You have anything?
No.
Upon a plea of guilty to criminal facilitation of murder, 2 counts, defendant shall receive a sentence of 5 years on each count to run, however, consecutively for a total of 10 years to serve. Thank you.
Thank you, Judge.
That would be 10 years to serve. Thank you. You are excused. Barron County Detention Center. Do you desire to do the men and then the women, or how do you desire to do it? Okay, we'll call David Buck, David J. Buck. David J. Buck.
Yes, Your Honor.
Are you David J. Buck?
Yes.
Born in 1982.
Yes, Your Honor.
Last 4 digits of social security number 2125.
Yes.
Bill, is this your client? David J. Buck?
No. New case.
It's a revocation.
Oh, this is a revocation.
Pretrial diversion revocation.
I hadn't talked to him about it. I guess,
Well, let's hear what they have to say about it. Come around, Mr. Stockton.
Your Honor, he has a 5-year
Come around and
sentence.
get behind the microphone.
He has a 5-year sentence on wanton endangerment first and fleeing and evading first. On 10/14, Mr. Collins was receiving complaints on Mr. Buck, and he went to the residence and found 8 long guns and one handgun.
Is he gonna be charged on those?
Yeah, there's a case being presented to the grand jury today.
We'll pass over this case until December the 12th. And by then you can determine whether you're representing or not, Mr. Bell.
Yes, sir.
Okay. Mr. Bell will be over to see if you can reach an agreement with him. If not, you need to fill an affidavit out or get another attorney if you can't reach an agreement with him, and you'll be here on December the 12th.
Yes, Your Honor.
David R. Buck. Are you David R. Buck?
Yes, sir.
Good morning, Mr. Buck. Were you born in 1954?
Okay.
Yes, sir.
Last 4 digits, social security number 4580.
Yes, sir.
You're here today on pre-trial conference on 24 CR 0080, 24 CR 0078. What does the Commonwealth have to say? You come around, Mr. Stockton?
Judge, just so the court is aware, GPA does need to be formally appointed in 24 CR 78.
We'll do that.
Thank you.
We have a pretrial diversion plea.
Mr. Buck, a motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yep.
Are you the same person that was just identified in 24 CR 0078 and 24 CR 0080? Is judgment impaired in any way today?
No.
Okay. Have you discussed this matter with your attorney and are you satisfied with her advice?
Yes, sir.
Have you had an opportunity to consider the evidence the Commonwealth has against you? You feel like you're fully informed?
Yeah.
Understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky State's Constitution. I'm going to go over those rights with you. You have a right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, right to be represented by counsel if you do trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. And the right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. Understand by entering a guilty plea today, you give up those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. And if I don't accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Do you understand that?
Yeah.
Ask you a few questions. Have you previously been diverted in the last 5 years? Have you versions in the last 5 years?
Yeah.
Have you felonies in the past 10 years?
Judge, I believe his last felony was in 2005. I do not know what it is that he said, but in conversation with him, when going over the paperwork, that was the date he had given me his last felony.
Well, that was 20 years, 19 years ago.
Yes, Your Honor.
That's what he says. You can check on that if you like to. If he isn't, we can set it aside later. You understand that if you successfully complete the diversion, this agreement, the charges will be dismissed, pretrial diverted, and you can get it expunged. Understand that?
Yeah.
You understand if you do not successfully complete the diversion, you will be brought back before the court. And if I revoke the diversion, you'll be sentenced after I received a pre-sentence investigation report and you'll be a convicted felon. Do you understand that?
Yes, sir.
Okay. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to indictment number 24 CR 78 for the charge of possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 2.5 years. Upon a plea of guilty to indictment number 24 CR 80 for the charge of possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 2.5 years. The 2.5 year sentences shall run consecutively for a total of 5 years, pretrial diverted for 5 years, supervised. The defendant shall enter and complete the Monroe Specialty Drug Court Program. The defendant is currently incarcerated and shall remain incarcerated until the morning of orientation. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours per week of gainful employment until gainful employment is obtained. And we were just notified that he was voted in and accepted into drug court this morning.
Congratulations, you've been voted into drug court. When will the orientation? The orientation will be Monday morning. Okay, and you'll be released. I'll sign a release or somebody needs to pick you up and bring you over to orientation. You understand that?
Yes, sir.
Okay. Are you pleading guilty in this case because you didn't commit the acts charged in the indictment?
Yeah.
And so your own free will.
Yeah.
Knowing your constitutional rights have explained it, still your desire to proceed and allow the court to fix your punishment. Let me have those papers up here.
Yes, sure.
Turn it to the signature page here. I'll get that. Is that your signature on there, sir?
Yeah.
Okay. We date these, Counselor.
Yes, Your Honor. I do
Okay,
apologize.
I'll accept and sign the pretrial diversion and we'll sign the order and they'll release you on Monday, okay?
Okay.
What cost in this case?
$380.
Court cost is $280. You'll be paying it $30 a month. Mr. Buck?
Mr. Buck? Yeah.
You don't have to come back up. You have court costs. You just pay it $30 first payment, 30 days from today, okay?
Okay.
Thank you. Brockman Carter. Carter, 24 CR 30, 24 CR 0080. You are Brockman Carter. represented by Mr. Bell. What, almost come around, what we have?
Could be.
I don't have an arraignment on here.
It should say.
24 CR 90.
Okay, let me have 24 CR 90 right here. Mr. Carter, you have the right to remain silent. The grand jury of Monroe County has returned an indictment charging you with criminal mischief in the first degree. You understand what the charge is?
Yes, sir.
Acknowledge the receipt of the indictment, the identity, client, waive formal reading and arraignment, enter plea of guilty, reserving all pretrial motions.
Yes, Judge.
Okay, and Mr. Stockton, you have 24 CR 30 and 24 CR 90. You wish to schedule this for a negotiation, or what do you want to do?
That's up to Mr. Bell. We had a trial set and then Mr. Bell said he was trying to obtain more evidence. We continued it today, so I don't know what he wants to do in this case.
Well, there was, anyway. Judge, I'm always open to negotiating, but you know, it's fine with me. I mean, I don't know if we can resolve it. We've tried, but
Well, if you don't think you can resolve it, which one of these cases is the court?
I'm not saying I'm opposed to
Well,
They will
resolving
need to
it.
be consolidated. The criminal mischief emanates from the fleeing and evading. There was a collision between Mr. Carter's vehicle and another one.
okay, I'll consolidate the two indictments for the purpose and let's set a trial date then. Was this a one-day trial, you think?
I would think so.
Mr. Bell,
Give me just a second, bro. Brock, do you want to set a negotiation day?
yes, sir.
I would ask for that.
Well, let's set a trial date and the negotiation date will be before then.
That's fine.
I mean, if you can't get it, I think he's got a right to a speedy trial. That's what I'm saying, you know.
I
We
understand.
can't reach an agreement on it.
I do not want the trial date. Got a bench. I know it's the 8th and 15th or something like that.
What about December the 13th?
Your Honor, I think there's too much set in December already. You've got Russell set, which is a 2-day trial. Then you got Keona set the 17th and we got Phelps set the 18th.
And I would ask the court to at least go to sometime in the first of the year, Judge. I'm stacked up myself. The Russell trial's my trial in December.
Okay, y'all have convinced me. But I see such a chord here.
That's the only time Mr. Bell and I can agree. Right?
What date is Clinton Circuit Court Commonwealth versus Duval supposed to be set on?
January the 8th. I'm in the wrong count.
So it's set on the 8th?
Yes, I do have it. That been over there. Amazing.
That opens up January the 13th.
Yeah, I don't have anything, John.
Mr. Bell?
Judge, I've got some sentencings and different things in Barron County, but I could get that passed if I needed to,
January the 13th.
or I believe I could.
Yeah. Then have a negotiation. You want that on January the 3rd, or you want?
Yeah,
that
the
next-
negotiation will be on January the 3rd.
You don't want to do the sixth, do you?
Well, if Mr. Bell said the December the 6th, that's,
You don't, if it please the court, Judge.
Okay, negotiation on December the 6th. The trial is on January 13th, and you'll need to do it, if you want him here, you'll need to do a transportation order, Mr. Bell.
Yes, sir, Judge. Judge, I would like to address bond very quickly.
You'll have to have a hearing. You have to, if you want to schedule a hearing, we can do that.
Okay, Judge.
And I'll give you one, you won't have to wait to the next rule day if you want a hearing, but we'll have to go on the record about. I've already heard pretty
I won't
extensive,
have any other proof.
I've heard extensive proof on it, you know, about the barricade and breaking in the door and.
I know, Judge, I was just hoping maybe he'd reinstated, he hadn't committed any other crimes and he's
You
got.
need to give me some proof or something. He hadn't committed any other crimes, he's been incarcerated.
Well, not during the entirety of the time he was
Well,
released.
you know, you
He
just
was out several months.
work with the Commonwealth on it. Y'all can reach some agreement. I'll take a look at it.
All
Okay?
right, thank you, Judge.
Okay, thank you. Tracy Davis. Tracy Davis. Commonwealth versus, are you Tracy Davis?
Yes, Your Honor.
Morning, Tracy Davis. This is 22 CR 0097. Were you born in 1972?
Yes, Your Honor.
4-digit social security number 7718.
Yes, Your Honor.
We're here today for a motion for shock probation. You want to proceed?
Your Honor, this was our motion for shock probation. However, after further conversation with Mr. Davis, he would like to withdraw that motion and wait on parole or MRS. He has quite a good bit of time in and is not too far off from those.
When is the last day they can file a motion for shock probation?
It's 180 days after sentencing.
I know that, but what is, where do we fall within that continuum?
I'm not sure exactly.
Well, here's the
where-
reason I'm asking you that. I can take this in abeyance or under consideration and that time period will not pass. If you wait beyond that time period and he gets rolled, then I won't have any jurisdiction in this case.
Yes, Your Honor.
So if you want to find that out, it would be good. I'll consider the motion will be withdrawn without prejudice.
Yes, Your Honor.
Stacy Eden. Mr. Davis? Mr. Davis?
Yes, Your Honor.
Explain that your attorney says you want to see what the parole board is going to do for you, and she's going to count your 180 days to make sure you have a motion in front of me in case they flop you. And
Okay, I appreciate it.
we won't lose jurisdiction of it, okay?
Thank you, Your Honor.
Yeah. Stacy Eden.
Yes, Your Honor. This was our motion requesting.
I'd like to get Stacy Eden in front of me.
Yes, Your-
Commonwealth versus Stacy Eden, 23 CR 0051. Are you Stacy Eden?
Yes, sir.
Born in 1989?
Yes, sir.
4 digits are 3700. Now what do you
Yes,
have?
sir.
Your Honor, this was our motion requesting an order from the court requiring the Department of Corrections to transport Miss Eden to a state facility pursuant to statute. People who are sentenced on anything above a Class C felony are supposed to be transported within 45 days of the date of their sentencing. Miss Eden was sentenced on September the 12th of this year on an assault first. It has been more than 45 days at this point in time. She is requesting for the court to enter an order for her to be transported.
I don't have any opposition. I think corrections need to comply with the law, just like the people we prosecute.
Submit an order.
Yes, Your Honor.
We'll submit an order directing the Department of Corrections to transport you.
Thank you, sir.
Jared Hale. For Rain. Are you Jared Hale?
Yes, sir.
Morning, Mr. Hale. Were you born in 1984?
Yes, sir.
That's 4 digits of your Social Security 9494.
Yes, sir.
You're on 24 CR 00089 for the purpose of arraignment. Did you have an Office of Public Advocacy in District Court?
Yes, sir.
Well, I'll continue that appointment then. You have a right to remain silent. The grand jury of Monroe County is returning an indictment charging you with theft by unlawful taking or disposition more than 10,000 but less than $1 million. Do you understand what that charge is?
Not really, sir. I sure don't.
Wait, I'm not asking whether you did it or not. I'm saying they're charging you with theft by unlawful taking or disposition more than 10,000 but less than $1 million. And so you understand they're charging you with something, and you understand what the charge. I'm not asking where you did it or not, okay?
Oh, yes, I really don't know what I'm being charged for, but I mean, yeah, I understand what you said.
Okay. I'm signing a reciprocal discovery order, sir, and they'll give you information so you can determine your defense. Your attorneys here, they'll deliver that. Okay, you're going, I guess we're going on December 6th for negotiation day and December 12th.
Yes, the grand jury have another indictment returned on a separate case, and I'll go ahead and put DPA and furnish them discovery on that.
There is evidently some additional evidence, sir. The Commonwealth said that the grand jury is considering today. What we'll do is that information will be given to your attorney too, so you'll be sure you have it before you enter into negotiations. And if there is an indictment returned, they'll serve you over there with the indictment. If not, they could proceed by information so that you can have all this wrapped up. You'll have everything you've got to deal with. Your attorney will be in contact with you, okay?
Yes, sir.
Thank you. Damian Hurt. Damian Hurt. Commonwealth versus Damian Hurt, 24 CR 0066. Are you Mr. Hurt?
Yes, sir.
Morning. Were you born in 1979?
Yes.
Last 4 digits, social security number 2714.
Yes.
Represented by Mr. Garrett, we have a pretrial conference. Is there a plea in this case?
There is, Judge.
What is it?
Judge, he'll receive
Is it a felony or pretrial?
felony plea.
Okay. Okay, let me go over it. I've been informed that a motion's been tendered on your behalf. It says you wish to enter a plea today. Is that correct, Mr. Hurt?
Yes. Yes.
Are you currently under the influence of drugs or alcohol?
No, sir.
Plea freely and voluntarily given.
Yes.
Are you the same person that we just identified in 24 CR 0066?
Yes.
Judgment impaired today.
No, sir.
Discuss these charges with your attorney, and are you satisfied with his advice?
Yes.
You read the evidence the Commonwealth has against you, and you believe you're fully informed about your case.
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. We'll go over them and then ask you, okay? You have the right not to testify against yourself. No one can make you say anything. Trial by jury, the right to be represented by counsel at your jury trial, the right to cross-examine all witnesses called to testify against you, the right to produce evidence, call witnesses in your favor, and the right to appeal this matter to a higher court if you lose. You have the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of the charges against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes.
I may consider the Commonwealth's recommendation, but I can sentence you to any sentence provided by law. Prior to accepting that recommendation, I will await a pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your guilty and proceed to trial. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to complicity to theft by unlawful taking or disposition over $10,000, the defendant shall receive a sentence of 10 years. Upon a plea of guilty to complicity to burglary third degree, the defendant shall receive a sentence of 5 years. Plea of guilty to facilitation to criminal syndicate engaging in organized crime, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to receiving stolen property over 10,000, the defendant shall receive a sentence of 10 years. The 2 5-year sentences shall run concurrently for a total of 5 years. The 2 10-year sentences shall run concurrently for a total of 10 years. The 5-year sentence and the 10-year sentence shall run consecutively for a total of 15 years, probated for 5 years supervised. The defendant shall pay restitution in the amount of $45,000 that's jointly and severally liable with co-defendants Jody Murphy, Michaela Pettico, and Joby Grace at a monthly rate of $250 per month, with first payment being due within 30 days from the entry of this plea and all subsequent payments being due on the same day thereafter. Restitution is subject to a 5% clerk's fee in addition to the $45,000 and shall be added to each monthly payment of $250. Probation shall continue until restitution is paid in full. The defendant shall have no contact with the victim or victim's real property. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style case forfeited and destroyed in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to, sir?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes.
And so of your own free will?
Yes.
You waive your constitutional rights, allow the court to proceed to sentencing and punishment in this case? You understand that after a guilty plea to any future, after this guilty plea, future conviction to felony could allow a felony to be enhanced under persistent penal law. Is that your signature on the document? If you hand it up here, I'll hold the signature up. That's your signature. That's your signature right there, sir?
Yes.
Okay, well, I'll accept the plea, sign the restitution order, have a pre-sentence investigation report done, and schedule sentencing for December the 12th.
Judge, one other issue.
Now, this is a probated sentence.
It is, Your Honor.
Would you look to be released or held?
Well, I didn't realize until Mr. Garrett told me this morning that the court had revoked his bond.
I'd ask him if we could reinstate the bond. It is going to be a probated offer.
Why did I revoke it? I forgot.
He's got a trafficking charge out of Barron County.
And he'll post the bond over there as well.
Well, if he posts a bond over there, then contact the Commonwealth attorney and I'll reinstate the bond here.
Okay, thank you,
Okay.
Judge.
Okay. Brian Roberts. Brian Roberts. Brian Roberts.
Yes, Your Honor.
Morning. This is here. You're here on 20 CR 0025 and 21 CR 0099. Mr. Roberts, were you born in 1992?
Yes, sir.
Last four digits, Social Security number 7584.
Yes, sir.
Okay, what Commonwealth have to say?
Yeah, this is the Commonwealth's motion to revoke probation. He has a 3-year sentence on fleeing and evading first. He got new charges in Barron County. And he was charged with fleeing and evading that down over there. It was amended down to trafficking and fleeing and evading third. Mr. Cross proposes that he go to rehab for 6 months and the Commonwealth concedes. And if you want my reasoning, I need to approach.
I'm sure you have a good reason. Okay, well, when will you, who's getting the bed date?
We'll get it. He's made a spark, so we'll get that promptly and get it filed.
Hey, now, these days that he's been in will be a partial sanction,
Yes, Your Honor.
partial sanction, and he go to rehab.
Yes.
Okay,
And he won't be released till the bed day. Right.
they'll find you a bed date in the rehab.
Thank you.
All
Your
right,
Honor.
thank you, Your Honor. I've already spoken to Mr. Cross and I just need him to give the lady the okay to send my payment.
Wait. You don't need to say anything else here, okay?
Things going well.
He'll talk to you.
Thank you, Your Honor. That's all I have to say.
Commonwealth versus Robles. Robles. Robles, 23-0050, you are Jose Robles.
Yep,
You born in 2000.
yep,
It's 4 digits, social security number 4313.
yep.
Okay,
Judge, this is one that we'll be doing a mediation on. Some of the courts still okay with that.
yeah, we scheduled, what did we schedule the meeting appearance after the mediation?
January 16th.
January 16th.
Okay, the next court date is January the 16th. And we'll have a negotiation before then, okay?
Thank you.
Timothy Shirley. Over Timothy Shirley. 24 CR 0028, 21 CR 0058. Mr. Shirley, were you born in 1969?
Yes, sir.
Last 4 digits, social security number 6465.
Yes, sir.
For a probation revocation and a pretrial conference, what do we have?
Judge, we don't have this resolved. We did enter an agreed order reinstating Mr. Shirley's bond. It had been revoked because of a misdemeanor charge that has since been dismissed. And Mr. Snarkin agreed to reinstate his bond.
They were making a bond, hasn't he?
Well, he had been out for some period of time on an ankle monitor on his own recognizance. That's before he got that misdemeanor charge. About sometime last month, and he's been in now on that. The order's been tendered to the court, just hasn't been signed yet.
That's correct.
What is the new charge?
It was a assault 4th degree, but it's been dismissed.
I'm talking about 24 CR
He's involved on
0028.
the other syndicate case with Chad Shirley, Evelyn Shirley, and this is the one I asked that we passed Chad Shirley next month. That'd be the same thing on Mr. Shirley. If I can't get them resolved, I'll get trial dates.
Okay, December negotiation date on December 6th, the next court date on December 12th. How do you feel about his
I
bond?
would ask that it be reinstated.
Okay, we reinstate your bond.
I think so.
Okay. Both of those dates are conditions of your bond.
Well, the court pleases Miss Murphy has arrived and we're ready to proceed whenever.
Your Honor, can he come see me tomorrow if he gets out?
You need to come to probation and parole office in Glasgow and Tompkinsville tomorrow, okay? Probation.
Thank you, sir.
Tomorrow.
Hey, excuse me, sir.
Yeah, that's, yeah.
Would I have to be with ankle monitor?
Well, was that part of his previous condition of his bond, his ankle monitor? You want ankle
It's in the
monitor?
agreed order, yes.
Yeah, you have to sign back up for it tomorrow sometime too, okay?
Thanks, sir.
Who is this lady? Side here now?
Cody Murphy is here.
Still got a few.
I know I've got a few more. We'll get to her when we get there. I've got Seth Graves. Seth Graves. Cromwell versus Seth Graves, 24 CR 0075. You are Seth Graves.
Yes, sir.
You born in 1988.
Yes, sir.
Last 4 digits of social security number 4888. Here for pretrial conference. What do we have?
Felony plea, Your Honor.
Been handed a motion here that says you wish to enter a plea today. Is that correct, sir?
Yes, sir.
Drugs or alcohol?
No, sir.
Plea freely and voluntarily given.
Yes, sir.
Are you the same person we just identified in 24-0075?
Yes, sir.
Is your judgment impaired today in any way?
No, sir. No, sir.
Discuss this matter with your attorney and are you satisfied with her advice?
Yes, sir.
You reviewed the evidence the Commonwealth has against you and you feel like you're fully informed about your case.
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against anyone. Nobody can make you say anything. The right to speedy trial by a jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in favor, the right to appeal this matter to a higher court. If you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering guilty plea today, you give up all those rights. You understand that?
Yes, sir.
We consider the Commonwealth's recommendation that I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting your recommendation, I will wait the pre-sentence investigation for probation and parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Proceed to trial. You understand that? Mr. Stockton, what is the Commonwealth's recommendation?
Mr. Graves will plead guilty to burglary, third and persistent felony offender, second degree, receive a sentence of 10 years. He'll plead guilty to wanton endangerment, first degree, and persistent felony offender, second degree, receive a sentence of 10 years. They shall run concurrently for a total of 10 years, probated and supervised for 5 years. However, prior to being released, he shall enter and complete a dual diagnosis treatment center scheduled through DPA and agreed upon by the Commonwealth. The defendant shall remain incarcerated until the morning of the bed date. He shall have no contact with the 5-star convenience store here in Thompsonville, Kentucky.
Is that your understanding of the recommendation, sir?
Yes, sir.
Are you pleading guilty to the charges as amended in amended indictment because you did indeed do the acts that are charged?
Yes, sir.
You're doing so of your own free will.
Yes, sir.
Constitutional rights have explained to you is still your desire to proceed to allow the court to fix your punishment when the range permitted by the law. Is that correct?
Yes, sir.
Okay. You understand by entering this conviction, any future pleas of guilty to felonies or convictions to be used against you under the persistent felony offender law. You understand that?
Yes, sir.
That's your signature there, sir?
Yes, sir.
I'll accept the plea agreement or pre-sentence investigation report and have sentencing on December the 12th.
Yes, sir.
Thank you very much. Conception Lopez. Commonwealth Kentucky versus Conception Lopez, 24 CR 0084. Are you Conception Lopez?
Yes, sir.
Good morning. Were you born in 1977?
Yes, sir.
Last 4 digits, social security number 24 CR 0084. What does the Commonwealth have in this case?
I believe Ms. Hill needs another month because she has to have an interpreter.
Okay, December the 5th, I guess December 6th, actually. December the 6th for negotiation and December 12th, the next court date. What's he charged with?
Your Honor, in this case, he
Can you
is
speak
charged.
up, please?
Yes, Your Honor. In this case, he was charged with criminal trespass in the 3rd degree, possession of drug paraphernalia, possession or giving a peace officer false identifying information, criminal possession of a forged instrument in the 2nd degree.
It's the one where they found the ID in his billfold and he didn't present it, or did he present it allegedly?
No, that's a different case.
Different case, okay. Okay, well, make sure you have an interpreter.
Yes.
There. Will you need a separate interpreter, Mr. Stockton, or can you use their interpreter?
I won't be speaking with.
Do what?
I will not be speaking with. So I won't need an interpreter.
You won't be here at the negotiation.
No, I'll be here at the negotiation, but I will not be speaking with Mr. Lopez. I'll be speaking with his attorney.
Yes, sir.
Okay. Your lawyer will be over to explain things to you. They're going to provide you an interpreter for your negotiation so you understand exactly what's going on, okay?
Okay, so God bless you.
She'll be able to explain it to you, yes. Is Rush Garrett next? Rush Garrett? Are you Rush Garrett?
Yes, sir. I'm Garrett Rush, yes.
Garrett Rush or Rush Garrett? Garrett Rush, they had your name backwards here. Garrett Rush. 24 CR 0068 and 24 CR 0091.
Yes, sir.
Mr. Rush, were you born in 1982?
Yes, sir, I was.
Last four digits, social security number 5050. We're here
Yes,
for
sir.
arraignment on a case. You have a right to remain silent. Your attorney's here. The grand jury of Monroe County is returning an indictment charging you with failure to use a seatbelt, operating under the influence, license not in possession, possession of drug paraphernalia, and possession of marijuana. Also, possession of controlled substance, methamphetamine. You understand what those charges are. I'm not asking if you did those things.
Yes, sir.
Understand what they are. You acknowledge the identity of your client received indictment, wait formal reading and arraignment, enter pleas not guilty, reserving all pretrial motions.
Yes, Your Honor.
It will, I'll sign a reciprocal discovery order here to give Mr. Rush the information to prepare. We'll set a negotiation day on December 6th, and next court day on the 12th. We also have a pretrial diversion revocation in 24 CR that will be included in negotiations. Thank you very much. Your attorney will be over to see you.
Thanks, sir.
Rebecca Vibert. Rebecca Vibert there in the facility.
Yes, sir.
Commonwealth versus Rebecca Vibert, 24 CR 0083. Ms. Vibert, were you born in 1973?
Yes, sir.
What is your social security number? 6247.
Yes, Your Honor.
Pre-trial conference on 24 CR 0088. What does the Commonwealth have to say?
Have a pretrial diversion plea.
A motion just been handed to me, Ms. Vibert, that says you wish to enter a plea today. Is that correct?
Yes, Your Honor.
Influence of drugs or alcohol?
No, sir.
Plea freely and voluntarily given.
Yes.
Are you the same person we just identified in 24 CR 0083?
Yes, sir.
Judgment impaired today in any way?
Pardon me?
Is your judgment impaired? Do you know what's going on?
No, sir.
You don't know what's going on.
Yes, I know what's going on.
Have you discussed this matter with your attorney, and are you satisfied with her advice?
Yes, Your Honor.
You, the evidence the Commonwealth has against you, do you feel like you're fully informed about your case?
Yes.
You understand, you do not have to enter a plea of guilty today. You have certain rights. Before I can accept the plea of guilty, I know that you need to know that you understand those rights. I want you to listen. I'll explain. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter at higher court if you lose, the right to require the Commonwealth to prove it on a reasonable doubt against you. You understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes, sir.
Consider the Commonwealth's recommendation that I may apply in range of sentence allowed by law. I don't have to accept the recommendation. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty from the trial. You understand that? I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No, sir.
Felonies the past 2 years?
No, sir.
Are you presently on probation?
No, sir.
You say if you successfully completing diversion program, the charges will be dismissed, but if you do not successfully complete diversion, you'll be brought back before me and I'll make a decision on whether or not to revoke diversion. Would schedule a sentencing hearing and you would be a convicted felon that can be used against you in the future under persistent felony offender law. You understand that?
Yes, sir.
Doctor, will you tell us what the Commonwealth's recommendation is?
Yes, Ms. Vibert will plead guilty possession of a controlled substance first degree, receive a sentence of 3 years, pretrial diverted for 5 years, supervised. She'll enter and complete the Monroe County Specialty Court. She has been accepted. The defendant is currently incarcerated. She'll remain incarcerated until the morning of orientation. She'll receive credit for time served. Once released, she'll obtain and maintain gainful employment. All evidence in this case be destroyed.
Is that what you agreed to, ma'am?
Yes, sir.
Are you doing so because you committed the acts charged in the indictment as amended.
Yes, sir.
Okay, knowing your constitutional rights that I've explained to you, is still your right to proceed with a guilty plea charge and allow the court to fix your punishment.
Yes, sir.
Okay. I'm going to show you a signature here, and is that your signature on the document?
Yes, sir.
Now, I'm going to go ahead and sign your pretrial diversion agreement. It's already been voted in. The orientation will be Monday. So we'll sign an order releasing you on Monday. What time will the orientation be?
Somebody said 10 o'clock there.
Hey, have somebody over there to pick you up at 8:30 or so.
Okay, okay. Thank you, Your Honor.
Once you miss breakfast now, you know.
No. Thank you.
8:30. Okay, now, do we have anybody else on the docket except for the lady that was late?
And Judge, I don't mean to interrupt, but I was told I needed to log in. There was a court date that was called earlier that I wasn't present for. It's my apologies about that. But
What's your name?
This is Andrew Rhodes, Judge. This was Keith Gross's cases earlier.
Yeah, well, I've issued a show cause for you to appear here on December 12th and find this why you should not be held in contempt, and you've been removed from the case. There was information in the Commonwealth. They've sent you numerous communications, including plea agreements, and you've never responded, and you didn't show up today. I can't think, I'm not prejudging the thing, but if that's true, I can't think of anything. It's more discouraging to me as an attorney to have people sitting in jail without benefit of counsel with no response. Your client appeared on the Zoom here, said he attempted many times to contact you with no response. So you'll be here in person on December 12th.
Your Honor, I think Mr. Rhodes didn't have notice till Friday. He had a death in the family and was in Atlanta all last week. So I'm not sure he knew. I have already worked to restaff the case and believe I'll have an attorney available very soon.
He can be here on December the 12th, and you can present those arguments. I'm not going to prejudge him on it. He might have valid excuse, but it seems like a series of things, not an immediate action. That's a problem here. So you'll be here with your counsel on December 12th. Thank you.
Yeah, on December 12th, and I just want to make sure I understand, Keith Gross's cases that remain though are no longer with me.
You have no longer any responsibility. They're going to appoint someone else.
Yes, sir. All right. Well, thank you very much, Judge. I'll see you on December 12th.
Now, where's the case we have coming up? Where on the docket is?
Out of custody.
You want to bring your client Jody Murphy? Yeah, I'll withdraw the.
Judge, are you finished with us?
You have anybody else?
I'm showing Titan Neal and Abigail Vibbert.
Abigail Vibbert was passed.
We passed Abigail Vibbert, and who's the other one?
Titan Neal was a show cause.
We're not to show cause yet, but we'll get to that in just a second. Oh, so that one person there. Okay, now you are Jody Murphy. Leave your mask on if you've got COVID. What? Strep throat. Well, that's good enough to leave your on there. This is a pretrial conference in 24 CR 0060. What does the Commonwealth have to say?
We have a reversion plea, Your Honor.
Well, just stay there. I'll tell you when to come up here. We'll let the bailiff handle those papers right there. A motion has been tendered, man, that says you wish to enter a guilty plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Is this plea freely and voluntarily given? Are you the same person named in indictment number 24 CR 0060? Is your judgment impaired in any way? Have you discussed this charge with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Do you believe you're fully informed about your case? Do you understand that you do not have to plead guilty today? You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to go over them with you, and at the end, ask if you understand. You have a right not to testify against you. No one will make you say anything. You have to speak trial to agree. You have to be represented by counsel at your jury trial. In front and cross examine all witnesses called testify against you. Right to use evidence. Right to right to appeal this matter The higher court, if you lose, you have a right to apply the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand, but in a plea here today, you give up those rights. You understand that?
Yes.
I may consider the Commonwealth's recommendation, but I may apply in range of sentence provided below. I don't have to accept the recommendation. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty, proceed to trial. You understand that? We'll ask you some qualifying questions. Have you previously been diverted in the last 5 years? You have any felonies in the past 10 years? Are you currently on probation? You understand if you fully complete the diversion program, you have dismissed pretrial diverted and expunged from your record. You understand that?
Yes.
You understand? Not successfully complete the program, you'll be brought back in front of me. I'll make a determination on whether to revoke the pretrial diversion, schedule a sentencing hearing. Then you'll be a convicted felon that can be used against you in the future. You understand?
Yes, sir.
Step to your left, please. On over here. Mr. Stockton, what's the recommendation?
Your Honor, Miss Murphy would plead guilty to theft, unlawful taking less than $10,000, receive a sentence of 5 years. She'll plead guilty to burglary third, receive a sentence of 5 years. Facilitation to criminal syndicate engaged in organized crime, she'll receive a sentence of 5 years. They will run consecutively for a total of 15 years, pretrial diverted for 5 years. She'll pay restitution in the amount of $45,000 jointly and severally with co-defendants Joby Grace, Michaela Pettigo, and Damian Hurd at the rate of $250 a month, with first payment being due 30 days from the entry of this plea. That will be subject to a 5% clerk's fee, service fee, and that'll be paid each month on the $250 payment. Any restitution owed shall be due on the 58th month of the pretrial diversion. Supervision shall continue until restitution is paid in full. She'll have no contact with the victim or victim's property, receive credit for time served, obtain and maintain gainful employment, and pay court costs at discretion of the court.
Are you pleading guilty to, because you commit, come on back over here. Are you pleading guilty because you committed the acts charged in the indictment? Is that the agreement you read off? Is what he just read, is that what you agreed to?
Yes, sir.
Okay. Knowing your constitutional rights to explain it's still your desire to waive those rights and allow the court to fix your punishment within the arrangement of the law. Is that your signature on the document? Show her the signature.
Yes, sir.
Okay, I'll accept the order and the restitution agreement you present to the clerk over here. What did the court cost? $165. You make that at $30 a month in addition to the restitution. You need to meet with probation parole officer. Okay. Okay, let's go back to Barron County. The one person you got in show cause. What was that person's name?
Titan Neal.
Titan Neal. Yeah.
Okay, what? Mr. Neal?
Yes, sir.
What's the clerk's office show, Mr. Neal? Titan Neal, 23 CR 0060, you owe $85 in court costs. Are you in jail on a Monroe County charge now?
Yes, sir.
Okay. What is it charge he's up here on?
Possession of meth, I think.
Hold on, let me see, you're here on another case. When's that scheduled? This is a show cause. I'm on the show call.
He has a public intoxication and drug paraphernalia charge.
Yeah, they're gonna send him to drug treatment. Okay, I'm gonna give you 60 days. I'm gonna go ahead and schedule this out on February the 13th. You have the $85 paid by February 13th, okay?
Yes, sir.
Okay, thank you. I thank y'all for being patient with us, Barron County. You may be relieved.
Thank you, Your Honor.
Okay. Go to the show. The grand jury ready? Yes. Okay, bring the grand jury in. And then we'll get to the show cause docket here. Mr. Fox, are you gone?
I'm doing, I'm gonna take it back.
Okay, good seeing you again.
Good day.
Yeah. All rise for the grand jury, please. Okay, everyone can be seated. Who's the foreperson in the grand jury? Mr. Foreman, have y'all completed your work? Have 9 or more of you agreed to the documents you have? Present to the bailiff, please. Thank you, Mr. Bailiff. Still have to look at the calendar to believe that we're already in November of this year. You know, time passes so quickly, you know. And don't any of you younger people shake your head. You've got no idea what I'm talking about, but that's okay. Thank you for your service. I'll go ahead and get these processed. If these individuals are incarcerated now, we'll issue summons to them and include these additional charges. If they're not, we'll issue bench warrants. We'll assign a bond sufficient to protect the public or to make sure that they attend. So it's very important that you keep confidential any information that you receive in the grand jury. You'll next come back here on December 12th. It would appear that we got by the November elections without riots or insurrection, so you probably won't have to be called. I usually say you can be called back for riots or insurrection, so it doesn't appear that's going to happen, at least for that purpose. So thank you for your service. You'll be back here on December 12th. You're excused until that date or to further call. All rise to the grand jury, please. Let's go off the record. So, great. Okay, let's go back on the record now for everybody can be seated for show cause. Commonwealth versus Savannah Acosta. Shows 369.69 restitution. Okay, issue a show cause order. She can arrest warrant. She can purge herself of paying $150 toward the 363. Dalton Birdwell. He's incarcerated. We're going to pass over that till next month. Mark Brown, $40. Paid in full. Good deal. David J. Buck. Pardon? He's incarcerated. Pass over that to next month. He was over in jail and they didn't have him stay for that. Christopher Burks.
He's incarcerated.
Pass it over to next month. Another Christopher Burke for 927. Pass it over to next month. David D. Bird. Owes 30 more. Put him over to next month. Connie England. It's your bench warrant, $90 to purge yourself. Mara Ferguson. Okay, put the balance over to next month. Dylan Ford. You move from the docket. Justin Gillespie. Okay. December of last year.
No, we just continue with the next function.
Oh, okay. I thought you meant that's when they paid it. Okay. Billy Graves. Okay. We need to send it to that. Tyler Graves.
$50.
Okay, fine. Herschel Hammer, he's incarcerated, right? Pass it over the next month. Trina Hawkins. $155. It's a story on Trina Hawkins. You got anything on Trina Hawkins? Issue a bench warrant, purge yourself, and paying $155. Ricky Henson. $200, issue a bench warrant, purge himself, paying $200. Devon Howard is incarcerated. Pass over to next month.
He's a great head judge.
Devon Howard, pass over to next month. Devon Howard, pass over to next month. Justin Hunt. It's your bench warrant, purge himself by paying $500 toward the 3,883. Nicholas Highland.
$80 December.
Okay, put it on December 12th. Sean Jones. Bench warrant. Yeah, you were up here earlier today, weren't you? Yeah, what can you pay?
I can pay in the morning. First thing I took
How much?
advice, started hauling in cans and stuff. I just got to take them off. I don't know what they're burning. I've been tearing down the trailer too.
Okay, well, can you pay $50 for tomorrow?
Yeah, on both of them. I got two of them.
Okay, we'll just pay $50 by tomorrow and then come back December the 12th, okay?
Absolutely.
Okay.
Thank you.
Sean Jones, yeah. Sean Jones. Did you get your other one?
Yeah.
Yeah, pay $50. You need to start paying $100 or so a month. You got that restitution laying out there, okay? Okay, you pay $50 this time, and by the 12th, you start paying $100, and we'll get you set up. You won't have to come up here, okay? Okay. Timothy Jones.
$50 December.
Okay, put it back on December 12th. Courtney Mabry.
$40.
Okay, that's fine. Carrie Marley. Okay, bench warrant, purge 180 and set them on December 12th if they pay that, okay? Shannon McGuire. Bench warrant 250 and the rest of it be on December 12th. Charles Muse. Incarcerated, put him off to next month. Another Charles Muse, put him off to next month. Jesus Padilla, $9,450 restitution. Do a bench warrant, he purge himself by paying the entire amount.
I think it's over.
Yeah, I think so too. Ashley Pettigo,
$40 December 12th.
that's in full. Okay. Why is she on December 12th? She just owed $40.
She got another case.
The next case, yeah. Continued to December 12th, and she paid 40. Maria Rivera,
December 12th.
put it over again, just owes 17,024. Garrett Rush was here previously.
He's incarcerated, you know.
Put him over to December 12th. Alicia Samantha Russell.
She's pretty bad.
Put it over the next month. Patrick Harley Scott.
December 12th.
Fine. Kyle Simmons. Travis Smith.
$300, December 12th.
Okay. Benita Turner. Issue a bench warrant, purged for paying $141. Jamie Watson. Okay. Ansel Junior Williams. That'd be fine. Dakota Williams. Restitution. Issue a bench warrant, purge by paying.
He's in rehab.
Okay, put it off to next month. Okay, any of you have something you need to bring up to court here?
Those continued.
It's continued to December the 12th. Thank you. Any of y'all have anything? What do y'all have back there? Just watching, huh? Okay, you're welcome. And you? Just watching, okay? Then you can come back at 1 o'clock. We're finished till now, okay? Thank you very much. Is that it? Okay, let's go off the record. Is there anything else I need? Well, that's correct. Fox versus Fox.
December the 12th, please.
Gallup versus Gallup.
December the 12th.
I assume there've been some payments made on those.
That is correct.
Graves versus Graves.
December the 12th.
Turner versus Geffen.
December the 12th.
Hammer versus Hammer.
December the 12th.
Heston versus Heston.
December the 12th. A senior in high school.
Really?
That child is, so we're getting close.
They've been good customers. I hate to lose them. Taylor versus Houchins.
December the 12th.
Hudson versus Hudson.
December the 12th.
Okay. Jimenez versus Jimenez.
December the 12th.
Joyner versus Joyner.
December the 12th.
We're intervening into this.
Dye versus Jones.
That's our motion to intervene just so that we can start providing.
Got an order?
services that we.
Electronically file. Okay. Jones versus Jones.
You could swear Ms. Staples in, please.
Raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes.
State your name for the record, please.
Taylor Staples.
And you are familiar with the case of Sean Jones, file number 08CI205, is that correct?
Yes.
And Mr. Jones last made a payment on May 22nd, 2020, is that correct?
Yes.
And as far as you're aware, he's an able-bodied person capable of providing this support. He's neither incarcerated nor a member of the armed force, is that correct?
Correct.
Oh. He's not incarcerated. Mhm.
How much behind is?
25,000. And made a payment in over 4 years.
Yeah, then I worked for Josh and them. I thought Josh and them was taking it up, but apparently they wouldn't, but I ain't got a problem with paying it. I'm supposed to go to work. Supposed to have an interview with, CPC Monday or Tuesday. And I got a problem with paying it. I start paying it as soon as I get my job.
Well, I'm not gonna, obviously, you do have a problem paying.
Well, yeah.
Judge, we had asked to find him in contempt. The judge's arrears at $25,048.19. We gotta have some type of lump sum pay.
Well, here's the thing about it. I had him on the show cause docket earlier today, on court costs and things. I made some kind of arrangement on that. I don't know whether he's capable of making any lump sum payment or not. I keep on hearing about he's tearing these cars down and selling something, you know.
That's what I'm doing right there.
Well, I understand, but you've got to make some kind of arrangements with the county attorney's office. And, you know, the dog ate my homework. And so I don't have it stuff. It's got to end. And going to get a job, this is going to get a job. I don't know. What kind of lump sum did you have in mind?
Judge, I didn't know his condition at the time because we hadn't been able to have a response from him, so.
Well, let me ask you, if we'll continue this till next month, you come over there and you bring everything you got, tell them what, I don't want to say I'm going to get a job. I want what kind of job and what kind of wage assignment you can make to satisfy. And then you're going to need to stay with the same employer so the county attorney can be assured that the wage assignment will be good. Or I would say if you can't do any of this stuff, that they're going to recommend to go up and you be prosecuted on flagrant unsupport. And, you know, then you'll be going to the penitentiary. I mean, there's no excuse for not having paid this down through the years. I'm going to Cutawata. These children have expenses they've incurred, and the Commonwealth has incurred a lot of expenses.
18,000 of this is.
$18,000 where the other people that are out there being responsible and working are taking care of it. So just because we're past this next month, I'm just giving you an opportunity to go in and negotiate something with them and show them you've got employment.
to avoid another step, if we could go ahead and adjudicate his arrears.
I will adjudicate his arrearage.
25,048.19, we'll submit a.
I'll do an order on that and tell him to appear next month with either an agreed order having been filed or have us be here and show cause why I shouldn't find a sum amount to do that, okay?
She's the child support officer.
Okay, thank you very much.
Just call and make an appointment that way you'll be assured someone will be there.
Keith versus Keith.
Continue to December the 12th.
Okay. Page versus Page.
Ms. Staples, you're still under oath. Employed by the Monroe County Child Support Office. You're familiar with 2003 CI 117, Monica Price versus Kevin Page. Is that correct?
Yes.
As far as you're aware, Mr. Page is an able-bodied person capable of providing the support as previously ordered. He's neither incarcerated nor a member of the armed forces. Is that correct?
Correct.
He has an urge of.
You back there? Kevin Page, you want to come up here?
I looked around before I stuck it out. Okay. It's easy to hide behind Brad's head.
Are you Kevin Page? Are you Kevin Page? Okay, we're here on 03C10017.
You haven't made a payment since September of 22.
Have to be paid out.
It's not. Are you working anywhere now?
I'm just starting to want somebody, yeah.
What?
I've been meeting. Some shame. Some shame.
No, not. I mean,
some.
Okay, what's the deal here? You take some testimony from her and he can hear it. You're still under oath.
Does Mr. Page have an arrears of $21,554.55?
Yes.
Correct.
There's no way that could be.
He last made a payment on September 19th, 2022. Is that correct?
Yes.
And you've not been able to communicate or have any conversation with him prior to today? Is that
Correct.
How much for my last payment?
$35 on September 19th, 2022.
810.
What are you saying? Raise your right hand. Swear the testimony you're about to give is the truth, whole truth, nothing but the truth. Now, what's your side of this story on the 21,000?
I was paying 110 a week. Yeah. It should have been paid off.
When was the last payment you made?
Well, he says,
No, I'm not asking what he said. I'm asking you, when is the last payment you made?
I have no idea.
Well, I mean, was it a year ago? Wait, listen to me. I'm asking you some questions. You pay attention to me, okay? I'm trying to get you through this without getting you something done to you, okay? When's the last payment that you made?
I have no recollection of
A
that.
year ago, 2 years ago, 3 years ago?
Probably over 2 years ago.
How long?
Over 2 years ago.
Okay. And how much a month does the original order say you're supposed to pay?
$100 a month.
How much?
That was an arrearage payment. At one time, he was paying $1,000 a month in child support, something like that. 1,200.
Yeah.
How many children are there?
3.
Okay, well, what I want you to do is, before I enter a judgment on the 21,000, I'm gonna give you an opportunity to go over and sit down with them, bring any proof you have on anything you paid, so you get credit for anything that you paid, okay? And go over and make an appointment to Kirk, and I'm gonna ask you to be back here on December 12th to see if y'all have worked out anything and we can make arrangements for you to make payment. You understand what I'm saying?
I have to.
I know, but I'm giving you a chance to prove up what you paid. If you think you've made some payments other than this, they'll show you the orders and calculate it with you. And we'll make some arrangements that you can do to meet this obligation, okay? Okay, you got their phone number at the county attorney's office?
I can get it.
Okay, well, to call,
We'll submit a new order, just continuing this until December the 12th.
that'll be good. We'll continue it.
Put in there that he must contact our office and bring proof.
That's good. I think that's fair to you, okay? Okay, thank you very much, sir. You can go, yeah. Pennington versus Pennington.
Continue to December the 12th. We made the payment that we agreed upon last month,
Okay, Rich versus Rich.
December the 12th.
Brown versus Scott.
December the 12th.
Wilson versus Shelton.
December the 12th.
And White versus White.
December the 12th.
Okay. Thank you so much. Where's? No, I think I'm just gonna flip through the blue book here.
I'm not sure that every one of them has, some of them are on for review, but I don't have a motion.
Okay, if I pull one and we got it, shut it over, okay? Okay, we'll start the 1 o'clock civil docket. Beatty versus Boone. This motion to proceed in form of paupus, is that correct?
That is correct, Your Honor.
Did you submit an order on that?
I believe so.
Okay, we'll electronically sign it, seems appropriate.
Thank you, Your Honor.
Baxter versus Claywell. You know, this is a motion to declare a marriage void.
That is correct.
Okay, is this Mr. Baxter?
Yes, sir.
And you're Miss Claywell?
Sir.
Okay,
Sure.
explain this to me. It was very sparsely pled.
Judge, Miss Claywell was married up until 2014. Is that when it was?
I think so.
Yes, but in 2012, I believe, is that right?
Yes, sir.
Mr. Baxter and Miss Claywell got a marriage license and had a event solemnized as a marriage, but she was married to someone else at the time.
Okay. And I assume that the relationship is not well now. is it?
Correct.
Yeah. And are both of you in favor of voiding this marriage?
Sir.
Yes, Your Honor.
Yeah, you're saying it was inadvertent, but you didn't know that you weren't divorced.
I had filed with.
I'm asking you, you're saying that you
Yes.
thought you'd been divorced, okay? To avoid a bigamy charge, that's a good answer. So I will sign that order voiding,
Thank
okay?
Thank you.
Electronically submitted. Thank y'all.
Sorry, Mike.
Short versus Cook.
There's an agreed order tendered.
Agreed order tendered. It was a motion for access and writ of forcible retainer to enforce a writ of Cornelius versus Cornelius. Is there a motion?
This is my motion, just to set it for a final hearing. We did have a mediation.
If you'll speak up a little bit, it'd be good.
This is my motion to set it for a final hearing. We did have a mediation that we got the property and so forth out of the way, but we still have issues of custody for the two children. So I'm just asking.
How close are, who mediated this?
David King.
Yeah, how close are you on it?
Not very close. Not very.
Okay, well, I've got my calendar. How many children involved?
There are two, Judge.
How old are they?
Was it
14 and 8 or something?
Yeah,
Maybe 12 and 8. I'm sorry.
12 and 8. Well, one just started in preschool, I think, so maybe.
Let's look at December the 12th after the normal docket.
We have a new jury in that.
We have a new jury coming in that afternoon, so can you do it then? Okay. I guess if I stay long, how long do you think this is gonna take?
Take a couple hours, Judge, probably at a
Yeah.
minimum.
What time is the jury coming in?
2 or 2:30, Trace. Two.
I think I'd go ahead and schedule it for 3.
Yeah, 2 or 3 probably.
I would say we'll need 3 hours, Judge.
You moved it up to 3 hours.
I think 3 hours is probably
Okay.
saying, yes, sir.
I sure hadn't done much of a job settling this thing if it's gonna take 3 hours, but that's okay.
blame it on Mr. King.
Yeah, I thought you'd be inclined to do that. Do both parties still live here in Monroe County?
My car, no, she lives in Warren County, I think, right? And my client, has moved. I wouldn't know if he's permanently located back to Florida, which is where they used to live before they
Sounds
came
like a
here.
case that needs to be transferred to Warren County for the convenience of the lawyers to me.
It's not convenient to me. I'm in Barron County and the witnesses,
Perfectly convenient to me.
witnesses are all gonna be here in Monroe County.
Yeah, I'm gonna be in Cumberland County though, okay. So I just throw that out there. In the old days, lawyers would rather go to Bowling Green than come over here because they could have dinner and that sort of thing, but now it's not that way anymore, okay?
I don't know what the docket is down there. I mean, I could ask my
Look-
client, he and I have just not discussed that issue, so.
Okay. What about next week would be too quick, like the 19th, probably too quick for y'all. Is the 19th all right?
That
Too
would be,
soon?
that would be too soon for me.
Yeah. What time, I have a flight out on December 3rd. Do you have any idea what that is? What is the Monroe versus Russell case on the 9th and 10th? What is that about?
Take 2 days.
Well, I got it scheduled for 2 days, yeah. How about the 11th?
December.
December.
I am in a trial. So
That's no good then, okay?
it's Warren County.
The 17th, we have a criminal trial here, scheduled Miss Assistant Commonwealth Attorney on. That's going also, right? Okay. How about on the 16th? December the 16th.
I have an EPO hearing in Warren County at 1. I don't have anything else. I don't know if you're talking about morning or afternoon.
I can do it in the morning.
That works for me.
Hey, let's do it in the morning at 9 a.m. on the 16th. Sixteenth
It's fine.
at 9 a.m. We will continue, we will try that thing till we finish it, okay? However long it takes. Okay, thank y'all very much.
Thank you, Judge.
You're gonna exchange witness lists or any other things or any kind of other discovery? got the property out of the way. This is
I think
purely about custody,
really about-
time sharing, custody, that sort of thing.
Yes.
Okay, thank you.
Thank you, Judge.
England versus England. Hello.
Good afternoon, Judge.
We have that. Can you find that one for me? Oh,
Your Honor, I represent Ms. England. This is a motion to show cause for failing to comply with the parties' separation agreement regarding their home. Mr. England received the home in the separation agreement. He had 30 days to get refinanced. That's long since passed. We've tried to, or my client has tried to communicate with him to achieve that, to no avail.
is that the only thing that's resolved? What are you gonna do about this, Mr. England?
I've got it going to the bank right now.
What do you mean you gotta go into the bank?
They're, it's in the middle of getting her name off of it as we speak.
Show him that document that you got.
Okay, that's dated yesterday, so I had not seen that.
Yeah,
but,
okay, well, that's a step in the right
that's a
direction. You think there's a good possibility you get it refinanced?
Yes, he said it should be done by the 28th of this month.
Yeah.
Your Honor, one thing I would like to address, though, I mean, it seems that this activity has started since I filed my motion in October. My client's out an attorney fee. I'd like to, if it gets refinanced, I'd like my attorney fee to be paid out of those
Just
proceeds.
get another $500 in that, for attorney's fees, because they had to come up here. You probably charge more than that. These Glasgow lawyers more expensive than these poor old Clinton County lawyers are, but $500 is reasonable. You didn't incur an attorney's fee yourself, and I'm not going to hold you in contempt. So just add the $500 in that to pay for the attorney's fees. And then I'm going to reschedule this by December 12th. And if I'll receive a release from Mr. Alexander if it's done, and we'll be on our way rejoicing, all of us. Okay?
All right.
Okay. Thank you very much.
Thank you.
Could I get a copy of that?
Turner versus Guthrie.
Your Honor, we're just needing to set a trial date. We were hoping for maybe January. We are,
Is this your client coming up here?
yeah, she's fine, yeah.
Come on, you're welcome. What's the primary issue? It was sparsely pled here.
It's just custody and time sharing. We're gonna try to mediate this in December.
Well, I scheduled that other hearing. We'll not do this one on the same day.
We could do that afternoon. If that works for, I think that day's, well, I don't know, Mr. Hampton, I know you're involved in both
That's
those cases.
December, you talking about December 16th. We're gonna mediate this. We hope before the year's out. We were looking for a January date in case it didn't
Let's
work.
just go ahead and have a hearing.
Well, we haven't had an opportunity. Mr. Hampton's just been in this case for,
You got between now and then to talk to each other about it. Or you can mediate it between now and then.
yes, we were gonna use Mr. Alexander, Rich Alexander, to mediate it, and that's the
I
earliest that he
suggest
could.
you mediate before the 16th. I just don't want, I'm new at this, and I just don't want to get backed up, okay? And I've got a day available here, and then things pick up in January, February, and March. Here around the holidays, you don't have so much. I think that's over a month from now. You don't think you can talk to each other about that? I mean, is this?
We just felt a third party would have been a little bit easier for us to try to come to a resolution on this. And that's why we
If
were,
y'all don't want that date, that's fine.
I prefer not to have that date, Judge.
Okay, then I'll just wait till I hear from y'all.
You just want us to, we'll just come back and
Read
mediate.
document. I'll just wait till I hear from y'all, and hopefully you can reach an agreement with each other that how many children are involved. Well, I don't want to get into the issues, but hopefully everybody remember that they're going to be parents of these children for a long time. And if you can reach some kind of agreement, it's better for everybody. Okay, thank you.
Thank you, Judge.
I didn't know it worked, but threatened to give someone an early hearing date before. I tried that. McClendon versus Hall. Okay,
Your Honor, this is my motion to set this for a trial. I
Okay.
represent the petitioner, which is Ashley McClendon and her husband. This is one of those de facto custodian complaints. This is the biological mom of the child. The father is Charles Muse. He's currently incarcerated,
saw him today, I think. You know.
but it's my understanding he's going to be released soon. So we were just wanting to schedule this for a hearing because I don't think there's going to be any type of resolution in this case.
You're the biological mother.
She
You're the
is.
biological mother, and you've had, what's your relationship, y'all? Friends, associates? I mean, she just.
No relation. She's
been
just,
taking care of the
she's been
child.
taking care of the child.
Okay.
Um,
Do you
That-
think Mr. Muse, was there a guardian ad litem appointed?
There
Because
wasn't.
He wasn't incarcerated at the time of the motion.
He got served with the petition and the motion while he was incarcerated. So if the court wants to appoint him a guardian ad litem, we wouldn't
Well,
have an
is he getting
objection,
out?
but we do believe he's getting out.
Well, let me tell you when he's getting out.
He should be getting out today.
That's what I thought.
Yeah.
Okay, well, let's just schedule, once you redocket this for December the 12th,
Okay,
and we'll determine whether he's in agreement with having having her to have a de facto status.
okay.
And we can have a short hearing about de facto status on that date, probably. We have a jury in that afternoon. Do you
Okay.
think there's gonna be long evidence about the de facto status? He's not here yet.
I don't think about the de facto, no. Would you want me to schedule it for 2 or 2:30 or after the jury?
We'll just schedule it for the regular motion hour and see what he says. And if he
Okay.
says something different than that, we always have that other December
That's fine.
date.
That December date. Okay, that sounds good.
Okay? We always have a hearing that December date. So when you talk to him, if he contacts you, you need to tell him that he can be here and reach some kind of agreement on the 12th, or that I'm looking at that date.
That sounds good, Your Honor.
Okay?
All right, thank
Thank
you.
you very much. Hammonds versus Hammonds. What we got here? Okay, Hammonds versus Hammonds. What do you have?
Good afternoon, Your Honor. I'm standing in for Ms. Adkins this afternoon. My colleague, she's filed a motion to get a hearing date in this case, I believe. The other party was served via warning order attorney, is my understanding.
Is it a divorce case or a custody case?
Divorce, Your Honor.
Where is he? Where is the spouse? Hartson, where was he last time you heard where he was?
Elizabethtown. Yes, I know that Mr. Carter filed,
Is there any personal property involved?
no, I don't think there's any property, Your Honor. There is one child, 11 years old. I don't anticipate it would be a lengthy hearing.
Let's schedule it for that. What date was that? We had the hearing, 16th. December 6th, was it December 16th? December 16th, okay with you?
Yes, Your Honor, that would be wonderful.
Right.
Your Honor, what time was that?
What time we have the other one scheduled? 9, why don't you do it 11? Okay,
Yes, Your Honor. Thank you.
Hellman versus Heilman, versus Heilman.
Your Honor, that was my motion, but I renoticed it for December.
Okay, thank you. Jenkins versus Jenkins.
Judge, that's my motion. Mr. Anderson has informed me that he has no objection to excluding those two parcels, but he asked that I file a full formal amended complaint so that he can respond to it since he wasn't in the case when it started.
Paragraph that way.
Yeah.
Makes it easier than have to recite the facts, just deny paragraph so and so, right? Okay. You submit an order?
I'll submit an order with the amended complaint, and then he wants 30 days to respond once I
We'll
file that.
circulate the amended complaint to him. He might help you making corrections on the complaint early if there is anything he disagrees with it.
Well, that's why he wants 30 days to respond to it, so we can
Well,
back out the sale date.
I'm trying to shortcut that, but go
Well,
ahead.
that's what purpose of this motion was quicker than adding parties that now own this
Yeah,
when they're just gonna be dismissed.
okay.
Yeah.
Thank you for your help. Wood versus Terry. Wood versus Terry. Are you Jamie Beth Wood?
Yes.
Okay, what do we have here, Counsel?
Your Honor, this is my motion for a final hearing. Mr. Terry is
Set it
incarcerated.
on the same date,
Yes, Your Honor.
11:30.
Thank you, Your Honor.
Okay, now,
May I be excused?
absolutely. Where's the rest of the docket? We have, is that Clinton County case here, okay? Clinton County case being heard by agreement here in Monroe. Huff versus Brumley. Now let's go over again. Is this Ms. Huff? Ms. Huff, okay. You represent,
Judge, I'm standing in for Miss Marley today. She could make it.
you represent who? Morgan and
It's our own
Morgan?
interest, yes, sir.
Morgan and Morgan. You represent,
Kentucky Farm Bureau on the non-wage garnishment.
yeah. And
Yeah, I represent Ed Bromley, who was the defendant in this case.
okay. Now, it appears to me and so who was the insurer?
Ed Bromley,
Who he was the insured?
Yes, sir.
Who was the insurance company?
Kentucky Growers.
Kentucky Growers. I'm just trying to get everybody straightened up. So let me just go about this the way I understand it. It appears from the record, ma'am. How much is your claim for?
So the judgment out of Pulaski County is for $125,000. She was DUI in that motor vehicle accident, which means under the US Bankruptcy Code, 11 USC 523, that is not dischargeable in bankruptcy because it was a bodily injury claim.
Okay. I'm still a bit confused on the thing. She signed a contingent fee agreement with Morgan and Morgan.
Yes, sir.
This judgment you had, was it on the wreck? What
A
was
separate wreck, a wreck that occurred in Pulaski County.
a different wreck?
Correct.
Okay, so
Not
she was
involving these parties
okay.
other than.
So you had a judgment lien for correct. And so she settles with your insured.
Yes, sir.
For
She fired her attorney.
Well, yeah, and then settle for 75,000.
Yes, sir.
And there was an offer on the table when she fired you for 150,000.
Additionally, if I may, Your Honor.
Please.
Edmund Brumley became aware of the $150,000 settlement and sent this letter to Kentucky Farm Bureau. That's his handwriting. And he says Tracy Huff is looking to get about 90,000 settlement in a week or two. 90,000 is the remainder after Morgan and Morgan's contingency fee on the 150,000. Farm Bureau immediately made me aware. The date of the fax is January 8th, 2024. And that's when I
understand what's happening.
Did the non-wage garnishment and got it to Mr. Piscano.
Yeah. There just seems to be something basically wrong here to me, where an insurance company that is defending a case makes a settlement offer to an attorney that's representing somebody. And then shortly thereafter, the attorney fires the representation and settles the case for 50 cents on the dollar. I don't think I would want to go in front of the insurance commission or anything on something like that. Just,
One other thing, we did say we were gonna pay her medical bills.
well, how much are her medical bills?
I think they're about 25,000.
Okay.
Your Honor, if I may, last I saw in our file, it was closer to 94,000, but I would have to verify.
The medical bills were?
Correct. I would
Now,
have-
where would you fall in line with your lien? With medical bills would come off first, correct?
If that was part of the agreement, but there's nothing indicating that.
I
Again,
don't,
Mr. Brumley said that she was getting 90,000.
well, I don't know about Mr. Brumley. I'm taking that will be introduced at some later juncture. It appears we're just getting scraping the top off of this thing here. But let's say there had been a settlement for $150,000. They get their contingent fee. Okay. And then you would come in and you'd filed your attachment. You get paid your money. Where would the medical bills come in as far as priority of payment out of that $150,000? If the $150,000 was a total agreement, or was there, I think there was $1,000 provision for medical bills, your agreement. Am I remembering right?
Yes.
Okay. Where would the medical bills, would they have any lien that would be superior to your lien as far as collecting the medical bills out of the judgment amount? I'm asking you and then I'll get to you.
Only if they had perfected that lien by either intervening into the personal injury case between Huff and Brumley.
The medical providers.
Correct.
Unless it was
Or the
Medicaid or
health insurance carrier. It's subrogation, just like Kentucky Farm Bureau's case is. And they would have had to have intervened and perfected that lien in order to be a priority over my garnishment. My case has a judgment.
Yeah.
In Pulaski County. We issued a non-wage garnishment, and that garnishment has hit. It has stuck to the $150,000 settlement that Ed Brumley spoke about to Farm Bureau.
Yeah, what do you have to say?
Well, Your Honor, I was gonna say the medical bills are under a federal lien. They're Medicaid, Medicare, so that has to be paid first.
I would think that would be true.
Federal.
I don't see how you escape those. If this company had if these lawyers had collected that, usually if there's enough money, they can collect their contingent fee, but I don't see how they escape paying these federal funds. I've never seen it. It's been a long time since I've handled a case like that, but I would never have settled a case and distributed any money without paying Medicaid or Medicare, to make sure they're there. And then there were these other providers too. So I'd be interested in you, and I'm not saying you're wrong because I'm sure you're handle these things all the time. I'm just new to this thing. And so I want somebody to show me how your claim defeats these federal claims and whether or not now, and as far as your company is concerned and your insured is concerned, you need to get ready to pay $150,000 or the Court of Appeals or Supreme Court is going to have to tell you different, because with this offer on the table and this lady coming back in and firing this firm and taking 75, I'm not going to do that. Somebody's going to pay this money. And I don't even know whether 150 was enough or not, but evidently y'all thought it was.
At 300,000.
Well, 300,000 what?
That's what he was covered, the coverage he had.
Yeah.
Mr. Brown.
Yeah, well.
We valued the case higher than what the 150 was, but that was the last offer on the table prior to.
Jeez, oh Pete.
The letter expressly states that there was $300,000 in coverage. Mr. Piscano's letter says there was 300,000 in coverage.
So you're saying I have the authority to set the entire settlement aside and let them lay where Jesus flings them? Is that what you're
It's
suggesting?
an agreement not at arm's length.
Well, I'm asking what you would think would be the most equitable and correct legal sort of thing is to say that they have a lien for it at least 40% of the last offer? Is that what you want, 40% of the last offer?
Correct.
Okay. And then if I set the entire agreed judgment aside, then you're still at risk because they might zero out in front of a jury. Okay, so your offer would have to be over to the side somewhere. And then you could, she gets a new plaintiff's lawyer. She doesn't have a lawyer. I'd say she'd have to lawyer up again. Correct? She lawyers up again and then try the case. And if she gets enough money to pay off the federal liens, if they have priority over you, which they might not, you might have priority over them. You won't be involved in the lawsuit. You'll just be waiting around to see how it finishes. Your people will be involved at some juncture. You know, your insurance company will defend it if I set the judgment aside.
But I'm representing Mr. Brumley, so that's the guy who I represent.
I understand how it works. You know, Mr. Brumley, did the insurance company hire you to represent Mr. Brumley?
Yes, sir.
Well, so we're talking the same thing. I understand that there's a separation and your primary responsibility is to Mr. Brumley. You have a duty there, but at some juncture, you know, somebody in the insurance company gave authority for you to settle this case.
I wasn't involved till after all that
Well,
happened.
they gave somebody authority to
Yes, sir.
settle this case. Who was involved?
They made that offer to Morgan and
Who's
Morgan.
they?
Kentucky Growers.
Okay, were they, I'm sure they were represented by an attorney at the time. Had they filed an answer for Mr. Brumley at the time, or?
That was all before they filed the lawsuit.
So that's the reason we don't have any lawsuits anymore, because the big firms, Morgan and Morgan, they settle all these cases out before they get, you know, before they get to trial. Be it good or bad, that's just the world we live in. So I'm going to set aside the judgment.
But we have a release and an offer to pay 75 plus meds. There is no judgment for us unless you're referring to his.
Well, I'm going to say that your release and your settlement is fraudulent.
Okay.
And I'm going to set it aside. There's no judgment, but I'm going to set it aside. I might be wrong. I might be wrong. I don't know, but let me tell you what, I'm frequently wrong, but never in doubt. So I want you to draw up an order, preserving your recovery of 40% of the last offer, and then you're out of it. Okay. Then I'm setting aside the agreed settlement. You need to retain counsel as a plaintiff to proceed with the case. And you need to wait to see how the thing goes, to see where your lien is. And if at some juncture, if you give me and serve on the other parties some law as to why you believe that you come in front of these liens that would be in place. See, that's the thing I don't understand is if you believe that these liens have priority, then these federal liens on Medicaid or Medicare, whoever paid it, then they were going to come after whatever was left from her $75,000 settlement, right?
Well, what we do is we send a letter to CMS up in Washington.
Yeah.
What's your lien payoff? We pay that generally.
Did you do it in this case?
We're required to.
Yeah, I know you, but did they do it in this case?
We have not, because we still have this release hanging out there, and then
I'm
all
not accusing you of anything. I'm just asking questions that I don't know.
we haven't done anything to.
Yeah, but let me say, if I just threw this out right now, at some juncture, the feds would come after this lady for that amount because she got a $75,000.
Your Honor, they can come after the attorneys if we don't pay that lien.
I understand that, but
So we would.
But you if you'd have sent them a letter though, and I mean, I'm just saying, if you'd sent them a letter, you said you'd sent the feds a letter, would you have paid them directly without her involvement?
That was part of our agreement. We said we're going to pay them direct.
Yeah.
And that agreement was in the release?
Right.
Well, you have a copy of that?
Yes, sir.
Let me see it. Was it attached? I didn't see that release. We've got it here. Okay, there.
Great.
I have it here. I found it. Yeah, I had overlooked it. Okay, I see that. Well, now if she tries the case and gets zeroed out, then there will be no obligation to pay these federal liens things, correct?
Not from us.
Well, nobody else has any responsibility. No way they ever get it from her.
Right. And I think the federal statute says if there is a judgment with money in it, then we have a right to it. Medicare has a right to it.
I think that's true. That's the reason I'm wondering about.
I don't know about it.
I know. Well, I'm going to take this under consideration and I want, if your client would contact his insurance company and see if his insurance company would be willing to honor that last offer.
Okay.
That could get you some relief, couldn't it?
Right.
Okay.
Do that.
And that could get you some relief. And then the liens that the federal government could have would be satisfied without putting her at any additional risk. Now, that's not going to leave very much money for you, but you've made some bad choices, you know, as far as signing some of these sort of things. And if you'd have taken that last offer, you would have, this is what would have happened anyway, because his lien would have attached to the money that y'all had in Pleasant, and the Medicare, Medicaid would have been taken care of under this agreement. I'm gonna give y'all some time. I'm just gonna ask you to come to when's the next Clinton County Rule Day? In December, maybe.
The second.
2nd of December. The 2nd of December, have y'all give enough time to run it up to the poll, or is it we need longer than that?
That's enough time for me. I just don't have my schedule here yet, but.
Well, that's the regular Rule Day over in Clinton County. This is Clinton.
Say
County.
December 2nd?
Yeah,
Yeah, I've got,
it's a Monday.
I'm in Eastern Kentucky. I'm in Carter Circuit that afternoon.
Well, we're here again here on December the 12th. So if y'all would check your docket,
Okay.
see on December 12th, and hopefully I'll receive an agreed order about that. If they'll come in at their 150, you can get yours. They all agree to pay the 150 plus the medical things. And how much is your judgment for?
It was for 125. If we get the 150, they get the 40%, which is 60,000. The remainder would be 90. We would get the 90. I would also say, for the benefit of this plaintiff or the judgment debtor in our case, that I have authority from Kentucky Farm Bureau that if we secure the $90,000, the judgment in Pulaski County for $125,000 will be settled. She will not have her license risked for the next 15 years. She doesn't have to worry about any post-judgment enforcement, et cetera, et cetera.
Okay, well, what she'll need to do is get counsel. You'll need to get an attorney to review that. So what it's going to say is that if this follows through, you could walk clean. All your medical bills will have been paid. The $90,000 judgment from the other wreck would be satisfied. Your obligation to these attorneys would be satisfied.
I've been pulled in between them, that's for sure.
Do what?
I said I've been pulled in between them, that's for sure.
You got whiplash.
Yeah,
Yeah. Well, that's true. Okay, well, thank y'all, and I'll be looking forward to see if we can work something out. I'm not setting aside yet. I'm holding it in abeyance.
Okay. That's all.
I'm holding abeyance and not setting it aside in anticipation that you'll come to an accord on this thing. And the only thing you'll have to do is put the rest of the difference between what you paid and the last offer.
And Your Honor, just, I think we can probably do that. I don't have authority to do that. But then when we settle like that, the plaintiff is responsible for all liens.
Well, we're gonna hold, when you settle for like that, they're gonna get their money. He's gonna get his money. That judgment that
I didn't mean to interrupt you, but there's a requirement for the attorneys on both sides when money is exchanged like that, that Medicare, Medicaid lien has to be paid first. So I thought
you said you were gonna pay the 150 plus the Medicare,
No.
Medicaid.
We were gonna pay her 75 plus the Medicare lien.
Well, what was your offer? Just 150? Wait a second. What was your offer?
The offer we received from the adjusters, 150 plus 1,000 in med pay.
And so y'all would be playing those lanes. So you'll be relieved if you pay the 150, and then y'all can argue out on whether you have priority over the Medicaid liens or not. That's correct. Is that perfect? You understand what I'm saying?
I do.
Okay. I misunderstood. Thank you for bringing that to my attention. Okay. So we'll get them out of it by doing their last offer. And because she accepted something half of that, so this is sort of thing, and we'll let you bring in, if they agreed to pay the 150, then it'll be up to you to prove to me that they should release the money to you on your attachment rather than pay it to the feds.
All right. Am I secure that my non-wage garnishment will still attach to that settlement?
It will attach,
I'm not
it'll
saying get
attach the
paid.
settlement, but yes, I'm convinced it will, but then we'll be up to seeing where you are in the priority of payment, whether the
Right.
feds get it or you get it.
But I'm saying I don't need to serve Morgan and Morgan with another non-wage.
I would,
Okay.
out of abundance of caution, because as counsel says, if the settlement it'll go to them. And she's already discharged them, but I don't know where else to put it unless you pay it into court. That might be the best. What would y'all suggest where the deficiency, just pay that amount into court?
Your Honor, I think that would be best.
Yeah, that way Morgan doesn't have anything, and Morgan's claim can be settled out of what's left. Who has the first 75,000? Where is it?
We still have that. We couldn't release it until we paid the medical lien and then all these.
So I would suggest that you pay your entire, if you can get to the 150, you pay it into court, and then you can get what you've got, and then you'll have to convince me. And somebody probably she needs to get an attorney or somebody to contact the feds. Y'all don't want to involve with counting the feds because you're not going to have the money. So somebody's going to have to notify the feds that the money's here. A lot of times they'll reduce a lien,
Well, that's why I'm, an idea that I have is, would it be of interest to the court that I negotiate the satisfaction of those Medicare liens based on the remainder?
I think that would be appropriate. Yeah.
We'll take care of that with Morgan and Morgan on what the medical lien is and making sure it gets paid.
That'll be good. I think that gets you out of a conflict situation. You have a potential conflict situation if you negotiate. So you and Morgan will work on the medical liens, getting them paid by the feds. And then you can present what that argument is on the thing and pay off and see if it's acceptable to him. If it's not acceptable to him, I'll rule on who has priority. Where the medical liens or your judgment lien.
Yeah, I guess my only concern is, and I think the court is addressing it correctly, is that having dealt with them before, they are negotiable. And so it's in my interest to get them to negotiate as low as possible. They have no interest in negotiating. If they say
Well, I tell you what, Morgan and Morgan's interest is going to be, if they don't negotiate them down, I might not give them their entire fee. I can give you what I consider a reasonable fee. So that's a good incentive for you guys to get your full fee, is to make sure you work those, that federal money down. Okay. I'm sure you do it all the time, don't you? Okay. Now, if you can, what do you have to say?
No, I was just, 150,000 and 75,000, and I'm here. There's a reason.
What is the reason?
It's just I let myself get intimidated, and that somebody can try me more or less, and that's how it
Who
went.
intimidated you?
Mr. Brumley, I was in a relationship with him. Yeah. Which I had Morgan to Morgan at the beginning. And, he had received some papers one day at that day, and it was like gonna take his property or something back. And
Well, that adds an interesting layer to the thing, probably.
that's when they was fired.
Does anybody want to bring up the rule in Shelley's case or the rule against perpetuities or anything? We have?
I think if it's okay, we'll work an order out with what you said.
Yeah, that'll be good.
Okay, thank you, Judge.
Thank y'all very much. Okay,